Good evening, and welcome to this session of the live learning classes conducted by the Board of Studies Academic of the Institute of Chartered Accountants of India. This is the third installment of this topic, Incorporation. We have covered quite a lot of ground. In fact, we've covered almost 100 slides, almost, I think, 90 slides. Okay. Yeah, 92 slides, almost 100, should say. So, balance we have to finish today. I'm sure many of you are here. Gunjan Devi is good evening. Good evening, Madam. Deepika also good evening. Thank you. And let's sort of get into the topic. I wish you all a very good evening. Let's get into the topic. Yesterday we saw entrenchment. I think fairly simple topic. Now, some small issues. Quickly we can finish this off. There is no need for us to spend too much time on this because from the exam point of view, I don't see this as great. Very important. See, there's a hierarchy. We've already seen between the memorandum and articles, the memorandum is superior. If there is a provision in the articles, which is not in accordance with the provision in the memorandum will prevail. Also, let us say that the articles of association permit the directors to borrow money. Agreed. But such borrowing will be subject to the scope of the memorandum, which is defined in the object clause. So the directors cannot borrow money outside of the main object. They can borrow money only for the purpose of the main object. So if that company main object is software, they cannot borrow money for carrying on trading business. Though articles permits me to borrow, but it is ultra vires the memorandum. Right. Now, even if it is mentioned in the memorandum, you cannot do something which is prohibited by the act. So the act will have superior. So the provisions of this act shall have effect. Notwithstanding, that means whatever may be said in the memorandum, whatever may be said in the articles, the act will prevail. The act is superior. Okay. Notwithstanding means ignoring, not considering. It doesn't matter. Suppose you are saying something and I am saying something, notwithstanding whatever you say, I am right. Means I am superior to you like that. In fact, in any section, if you see the word notwithstanding, it means that section is superior to any other section, some other section, or any other section. This word, just at this stage, I'm explaining in simple way. Later on, if I don't know if you study, it is there in final or not, whether you need it. But in interpretation, you will find when you're reading law, this is very important. Notwithstanding, if you find in any section, it means that section is superior. But suppose you see subject to in any section or any subsection, subject to the provisions of subsection above, that means this fellow who is having subject to is thoda kam hai. He is little less than that fellow who upar hai. So that means that fellow is better. Okay. The guy who is subject to whom you are there is superior to you. But if you have notwithstanding, you are master, he is servant. But if you have subject to section is servant, that section which is to which it is subject to is master. Just try to remember this. These are general rules of interpretation of law. This has nothing to do with company law. Any law, so more as a general basic I'm telling you. So next time when you read this, try to analyze where they say notwithstanding, where they say subject to. So the act will have effect, notwithstanding anything to the contrary. Even if it is told something different, the act will be prevailing over the memorandum, any agreement executed by the company or any resolution passed by the company. Okay, which means what? Whenever you draft memorandum, articles, agreement, resolution, you should see to it that it is complying with the Companies Act. That is why in any resolution, what we say, subject to the provisions of. appropriate sections, or that section itself will mention subject to the provisions of. That means this resolution will operate subject to that. If it is saying no means this is wrong. That's all. Okay. So this is the point. Any provision contained in the memorandum, articles, agreement, or resolution shall, to the extent to which it is repugnant. See, they are using the word Baba. I am not using. Okay. So repugnant, I don't know what is the equivalent Hindi word. I'm sure that will be even more complicated word in Hindi. So repugnant, that means what? Not acceptable. Repugnant. See, the way I'm telling it itself, you don't know. Repugnant, not acceptable. Okay. So it is not suitable to me. So to the extent that it is not acceptable to the provisions of the Act, to the extent that it is against the provisions of this Act, it will become void or be void as the case may be. Okay. So that part alone will become void. Suppose that goes to the root of the agreement, then the agreement itself is void. You got my point? Suppose that clause, which is repugnant, which is against the Companies Act, unacceptable to the Companies Act, is the root of the contract, then that agreement itself is void. Okay. Act. So section 6 starts with the words save as otherwise. Save as otherwise. So this means what? Save as otherwise means in case it is provided differently in the Act anywhere, that will apply. That means there could be sections in the Act that say that article can provide differently. So if there are such sections, then such section or such provision shall be valid. So then in many cases they say, if it's provided in the Act itself, they'll say, save as otherwise provided in the Articles of Association or subject to provision in the Articles of Association. The minute they use that word, you can be sure that article will be superior to this. So are you able to understand? These words, save as otherwise, subject to, notwithstanding, are all words used in the statute to create, superiority, inferiority relationships. So by reading it itself, you can be sure. For example, section 47 deals with voting power of members. Okay, is it the section 47 is applicable to a private company subject to its articles. So the articles of a private company can have different rules for voting right. Normally section 47. But if the article says 47 does not apply, then the AOA will become superior. Section 47 will not be applicable. It's very simple. If you concentrate and listen to me, you will understand. Normally, Act to superior, memorandum less superior, articles the lowest. Normally. But if in the Act, the section itself says subject to Articles of Association, or say, then subject to means what? Articles of Association is superior to this section. Section 47 says, section 47 is subject to the article. The minute you subject means what? The section that is using is servant, article is becoming master. So article will become superior. That's all. Very simple. Why they do it? Because private company basically has no public investment. So you do whatever voting right you want, you have, Baba. That's all, matter over. You can have your own rules for voting right. But if that article is silent of a private company, what happens? Article silent, then automatically 47 will apply. Only if the articles are providing differently, that will be superior. Okay. Because many of you will want me to repeat this. That is why I am myself repeating it once. So the memorandum and articles, once signed and registered, become a binding contract between the members and the company, and the members inter se. Inter se means with each other. So there is one binding contract between the company and its members, and the members inter se. Inter se means amongst themselves. Inter se. These are all unnecessarily confusing words. What to do? If you want to become knowledgeable, you have to learn words. Am I correct? amongst themselves. Inter se means amongst themselves. Okay, that's what it means. You can say repugnant is little more than in conflict. See, conflict is where this is telling in one way, that is telling in another way. Repugnant is unacceptable. I have given clearly, so don't try to worry about it. I have given the wording because people have doubt. I have given this word. Unacceptable is one step above conflict. See, conflict is where you are saying one thing, I am saying another. That is conflict. But what you are saying may not be repugnant to what I am saying. There is a conflict. Conflict can be resolved, but repugnancy cannot be resolved, my dear friend. Got my point? And once you say you are in conflict with each other, there are many methods by which I can break the conflict. I can say who is, for example, I can say you are superior to me or I am superior to you and then close it. Like that, we can make meaning out of it. But once what the other person is saying is repugnant, end of it, nothing can be done, unacceptable. Okay. So don't think that I'm correcting you. I am correcting you, but in the thing. Another word for save as otherwise, subject to. No, save as otherwise is the wording used here. There's no way we can see. That's all British words, ma. The English, old English words. There's no need for you to. No, you can't use any other word in that context. If you're writing a law, you have to use save as otherwise only. If you want, okay, ma, you want some word, I can't give one word. I'll give a phrase. Unless otherwise provided. Unless otherwise provided in this act. Are you got it? You can say that. Unless otherwise provided. Otherwise provided. Same otherwise will come there also. Okay. In other words, that section is speaking in a way other than this. Okay. Normal rule is article superior. I'm sorry, not superior. But that section is speaking otherwise. Okay. So if provided otherwise, or if like that. Okay. One good thing, if you want to become an expert in law, if you want to be seen as an erudite person, if you want people to think you are highly intelligent, then you should have the courage to use complicated words and know the meaning of these words. You should use the word repugnant rather than unacceptable. Only then you will be seen as knowledgeable. For the sake of teaching you, I'm giving simple words, etc. You understand? See, it is like that. Yeah. See, scholarship means knowing complicated words. I'm sorry to make this comment, but that's who it is. See, I'm telling you, suppose somebody is explaining, some Swamiji is explaining Upanishad to you. In order to make it easy for you, he might give simple words and simple examples. But the thought is complicated. And to explain that, we have to use very, very complicated Sanskrit words. But if he uses that, you won't understand. But a day should come when you will understand those words. A day should come when you will be able to understand the high philosophy of Brahma Sutra in Sanskrit, rather than listen to third-rated, second-rated explanations by Swamijis in English. Okay, so you should know the original language, whatever language it is, English also. The original Latin, the original English means you are more knowledgeable. This is I'm not saying if you don't know, no, you are wrong. I'm saying let it be an aspiration for you in the long run to become a person who can use such words freely. Because a day will come when you will become a senior member of the institute. At that time, if you use simple words or ganda words, they say, what? Yeah, this fellow, he's not able to understand anything. Everything has to be made simple for him. You got my point? But this stage, because first time you are drinking the milk, we have to boil it, we have to mix it with water and give it to you. But a day should come when you should be able to drink milk directly from the udder of the cow and be able to digest it and take it. Okay? Aspire for those days is all I'm saying. Okay? See, today, if you're telling partner, multinational firm or senior chartered accountant, see, we can't just be saying bye like that. So solidly we should be able to give opinions and reports and submissions and that needs use of language. Okay? So train yourself from now on is what I'm saying. Okay, good. As usual, I'm telling this more for general support to you rather than to hurt you or to make you feel bad. So think like how it will be, how nice it will be. See, everybody wants to go to heaven, but nobody wants to die. The process of becoming knowledgeable and able to speak needs reading, needs understanding words and all. But if I don't want to do all that, give it to me in simple words, Asan language mein bol, or even don't even speak in English. मेरा language में बोल, then what happens? You never develop the English. So the articles of a company contained a clause that on the bankruptcy of a member, so effect of memorandum is there is a contract between the company and its members. Okay. Here, there is a case where the articles contain the clause that on the bankruptcy, that means once he becomes insolvent, his shares should be sold to the other shareholders at a price fixed by the directors. That is what is contained in the articles. Now, remember, the articles is binding on the company and every member. Right? Be a shareholder was adjudicated bankrupt. Agreed. His trustee in bankruptcy claimed that he was not bound by those provisions. No. It was held that the trustee was bound because he is not coming qua himself. He is coming as a representation, as a representative of B's estate. See, once a person dies, the assets are called estate. The assets which are there, na, whatever it may be, estate means don't think it should be land, building and all. Huge 10 to 100 acres land. Even bank account balance is called estate. That fellow dies on 50,000 rupees in State Bank of India, that is estate. Once a person dies, whatever assets he is owning at the time of death is called estate. That estate has to be administered. Okay, that is in bankruptcy. In India, we have insolvency professionals today who do it. Earlier, we had assignee or receiver. Now there is no. Now, insolvency, bankruptcy, if individual, it's called bankruptcy. Company, it's called insolvency. Okay, so once a person becomes bankrupt, then trustee is born. That fellow is not coming in his own right. He is coming as representative of B. So, whatever terms are binding on B, who is a shareholder, will be binding on the trustee also. Because the contract, the articles is a contract between the company and every member. And members intersay. B was a member. Now he is no more. But the estate continues to be bound by the articles. And the bankruptcy trustee is only executing the estate. He is not doing anything else. Okay. I hope this is clear. Now, this is a nice case. Eli case. The articles of a company provided that Eli should be a solicitor for life to the company. Eli is the name of a person, not this. I don't know. In some parts of India, the mouse, is called Eli. I think even in Kerala, it's called Eli. Of course, Tamil Nadu, it's called Eli. I don't know Andhra accent. Some parts of the country, this vast country, this small rodent is called Eli. Not that Eli. Okay. So the articles of a company provided that Eli is the name of a Britisher, should be a solicitor for life to the company and should not be removed from office except for misconduct. Note it, Your Honors, the articles mentioned that Eli would be solicitor for life. Agreed. Agreed. But what is coming, again, answer the question. Articles are a contract between the company and members intersay. There is no contract between the company and Eli represented by the articles. But in the articles, the members have put, hey, Eli is such a nice person. Let him be a solicitor for life. Later on, Eli also became a member of the company. Chalo, no problem. After employing him for a number of years, suddenly, maybe Eli behaved badly, whatever, the company discontinued his services. Now, he being a member sued the company for damages for the breach of the contract contained in the articles. Now, little bit of common sense will tell us, Mr. Eli, come here. There is a contract between you and the other members vis-a-vis the articles. Agreed. But was your right violated? Was the right violated as a member or as a solicitor? As a solicitor, you have no right because you are not a party to the articles. So you got it now. There is no infringement of his right as a member. And with regard to the articles, he has no locus standi. I'm writing it on the board. Locus standi. Can anybody tell me what is the meaning of the word locus standi? It's a Latin term. Locus standi. Locus standi. Anybody can tell me what is locus standi? See somebody's giving answer. Thank you, Mr. Anubhav. Thank you. No, I want to know. Right, correct. Right to no, not strong position. No. Correct. Kuldeep Nagar gives the almost correct answer. Right to sue. He used this very nice words. Right to make plea. Plea is also correct. Because right, a suit is nothing but a plea being heard in court. Correct. Absolutely correct. But ground to fight. Okay, agreed. Ground to fight a legal matter. Okay. Or right. Deepika gives me a correct answer. Right to bring an action in court. I think that is the best answer. Right to sue or right to bring an action in court. Absolutely. Locus standi means right. You know why I asked you? Because I knew this could have been taught to you in Contract Act. See, there you would have heard, stranger to a contract cannot sue. Stranger to a contract cannot sue. Correct. So stranger to a contract cannot sue. That means there's no locus standi. So in that sense, Eli, you might have studied it in consideration. Chinnaya versus Ramaya. Stranger to a contract cannot sue, but stranger to consideration can sue, provided is a party to the contract. Consideration need not be provided by the promisee. It can be promisor. It can be provided by any other person. Okay. When at the instance of the promisee or any other person. So any other person can also provide. Promisee need not provide. But stranger to a consideration can sue, but stranger to a contract cannot sue. Okay, here, unfortunate Eli is a stranger to the contract. The contract is between the company and its members, and the members, it is say, Eli versus Positive Government Security Life Assurance Company. Some of you may be even thinking why this fellow is putting this photo and using Eli, Bali and all. Correct. I'll tell you, this is one mnemonic technique that I have used in the past. When I want to remember something, I will try to associate it with something very strange. Because I have a wide reading, you can link it with many, many things and remember. But if you do that, your memory will improve. Some people keep asking me, so I want to remember, so like that. I don't know what to do. The only way, see, suppose one or two of you here are all young people. Maybe you are having what is known as six packs. You do like this, your triceps are all coming out and all. No, I am a Buddha man. Now I come to you and ask you, sir, how do I develop my muscles, sir? Say, hey, you fool. You have to do exercise every day, man. Like that, you will tell me now. You will laugh at me and say, nonsense. Don't do exercise every day, sir. Don't waste your time. Same thing. This is also a muscle. So it doesn't grow just like that. Little bit effort. Some techniques are there like this to remember. Okay. Now we move on to the doctrines, which are called doctrines of. Three doctrines are there. Okay. Exam point of view, sort of important. Sometimes suddenly they'll ask you a question. So it is necessary for you to know. So ultra vires. First is the doctrine of ultra vires. Maybe some of you would have even studied the doctrine of ultra vires in foundation. I don't know the syllabus. Or maybe you might have studied it in some other professional course. Or you might have studied it in college. School, maybe some of you, depending on your, whether you did CBSE or whatever. So maybe they taught you in school itself. So ultra vires literally means beyond the powers. Okay. Ultra means beyond. You have heard, na? Ultraviolet. There is Vibgaya is there, na? The rainbow is Vibgaya, violet, indigo, blue, green, yellow, orange. Now, orange, red, there is Vibgaya. Now, violet is the upper band. Now, there is a range of light rays that are beyond violet. That is called ultraviolet, beyond violet. Similarly, you have infrared. Okay. So ultra means beyond, infra means below, intra means inside, within. Are you able to understand? Ultra means beyond, above. Intra, I-N-T-R-A, intra means between or within. Okay. So ultraviolet means beyond the powers. The opposite is intraviolet, which means within the powers. Okay. When a company or its directors violate the provisions of this act or any other law, such an unlawful act attracts penalty. It is ultra vires the law. You understand? It is beyond the law, beyond the pale of law. That cannot be ratified even with the consent of all the members. Understand? Something which is beyond the powers of the company cannot be ratified even by all the members. If the company itself cannot do, similar to, suppose the agent does something which is criminal, can it be ratified by the principal? Same logic. Okay. No. The criminal act cannot be done even by the principal. Who can ratify it? Something which I can do, only I can ratify. Correct? Same way, what the company can do. See, what I can do, there is no limit. I can do. Of course, we over a period of time, we put limits on ourselves by saying, I am chartered accountant. I don't know anything else. I can't do this. I can't do that. In my case, I decided, even though I'm a chartered accountant, I'll become a corporate trainer. I did my Master of Science in Management Systems from the BITS Pilani, along with engineers. I went on to become a corporate trainer for almost 1997 to now. I've been a corporate trainer and a practicing CA. So limits are placed by ourselves. Now, there are no limits to what a human being can do. But a company, bahut limits, a lot of limits are there. For example, it cannot do anything which is not mentioned in the main objects. So anything which is beyond the scope of the main objects is called ultra vires, beyond the box. Even the company cannot do anything which is beyond the scope of the definition of the main objects of the object class. That is why the main objects in the object class is very important. While drafting that, you have to be very careful. The ROC also will be very careful, MCA. You can't put all sorts of anything and everything under the sun and all, you cannot put. It should be specific to one area. Whatever is put in the main objects should be reflected in the name of the company. Got it? So you can't have Hyundai Motors Limited, but motors means generally automobile and okay, are you able to understand? But some companies, what they will do, they will be called conglomerate. That is, they will be having, which means they will have to have a huge authorized capital, and then they will put, for example, Reliance Industries Limited, very wide. So Reliance has power to do many things. Even there, suppose something is not mentioned in the main objects, they cannot do it. They have to amend the main object, include it, and then only they can go for limit. Okay? So when the directors exceed their authority, the company may ratify because it is intra-vires the company, but ultra-vires the directors. Simple example I will give you. Suppose that articles say directors can borrow up to 1 crore. Beyond 1 crore, directors have to get approval from the shareholders. Now the directors in an emergency borrow 2 crores without approval of the shareholders. Okay. Now, it is definitely exceeding power. Whose power? Only the directors' power. Their authority they have exceeded. The company can borrow any amount. So long as some fools are willing to lend, the company can borrow any amount. The directors without approval. Now they have exceeded and borrowed 2 crore. So they call for an EGM. And at the EGM, they say, I'm very, very sorry. They won't say even that. It so happens there was an emergency. What to do? We have done it. Please ratify. Please approve it post factum. Ratification means approval after the event. After the event. You understand what I'm saying? See, the girl and the boy know that the parent will never accept to the marriage. So what they do, they run away. They get married. Thereafter, they come and fall at the feet. Know what to do? Marriage happened. Know what to do? Ratify. Bless. So what to do? Accept what has happened. And maybe satisfy yourself. Okay, everything is for the good. Bhagavan, Raksha Karo. And then go on. That's all. I mean, I'm giving one example to make you understand. Don't mistake me. Okay. Even my father in those days, when I was a young man, when I was 19, 17 and all, I was very, very ruffian. But one thing my father will tell everybody, my son is a very, very obedient son. Everybody look at him. Oh, what this man is telling. My son is if I draw a line like Lakshman Rekha, he will not cross it. They will all say, oh, his father is telling about this fellow. Then he said, whenever I draw the line, he will ask him where to draw, and then only I will draw. My father was a very intelligent man. He drew a convenient line for me so that I will never cross that line. He knew which line I will not cross. I mean, it's more of a joke. In fact, once I was asked to address a group in a TV program on the Constitution of India, and that is, they were inviting professionals to comment on the Constitution of India in Chennai Doordarshan. So I was invited for one session. The interviewer was my own student in Company Secretary Institute. So he was very eager. I said, look here, I'm not even an advocate. And I know next to nothing about Constitution, Satish. What? No, sir. I know you will do something, sir. So he gave me some 15 sections and said, you have to talk on this. We will ask you a question, you have to answer. So I took my son's advocate. I took his jurisprudence book and I studied it for 2 days. I sat with the Constitution. There's a treatise on the Constitution, power of the president. And I found that the president's power is very peculiar in India. See, the president is the head of the country. He is the ultimate head of the country. But he cannot do anything without consulting the Prime Minister and his ministers. But finally, what he says is final. He is very peculiar. So before he does something, he has to consult the Prime Minister. But Prime Minister cannot do anything without President's ratification. President's approval. See, the Act of Parliament finally needs the President's approval. But the President cannot do anything without consulting the Prime Minister and the company. It's a very peculiar time. It is strictly locked back. That's what, then only I gave this example of my father. President was like my father. Before drawing the line, he will ask Prime Minister, I want to draw a line. Where can I draw? Like that. Then the Prime Minister will draw the line there, he will draw. Okay. So, why I'm telling this joke, I told at that time in President and Prime Minister. I'm sorry if I'm diverging, but think about it. Okay, law is like that. And so here the directors have exceeded the authority, means the members can ratify, provided the act is something which the company can do. But act which is beyond the scope of memorandum of association is ultra-vires the company. Therefore, void ab initio. Ab initio, you know what it is. From the beginning. Ab initio means from the beginning. Okay. It was never correct. It was never valid. It's called ab initio. Contract entered into by minor is ab initio. Actually, this is similar to that. See, why is a contract entered into by a minor void ab initio? Because it is beyond his capacity. Same way, the capacity of a company is defined by the memorandum, the object clause. Now, when some act is done which is beyond that, it is void. It cannot bind the company. See, the idea of contract entered into a minor is void is to protect the minor. Same way, this rule is to protect the company and the shareholders. Are you able to understand? Though, definitely it affects the unwary third party. It is a danger for the unwary third party. But remember, the third party cannot say, I don't know. You remember? Why he cannot say, I don't know? Because memorandum is not some hidden secret document. It is not some, Odisha file that you have to search and get. It is available to you, public document. Go and see. There I'm very clearly said. So, Doctrine of Constructive Notice. Now, who prevented you from going and doing it? Right? Without seeing that, you come and lend me money, now what can I do? See, the idea is very simple, ma. The purpose of this doctrine is to protect the investors, because think about it, sir. Mr. A is starting a company. Okay, Dubakur Industries Limited. Now, in the prospectus, he is telling very clearly, we are manufacturing electric vehicle. Okay, I happy electric vehicle, Modi ji is also telling, so we will invest. So why did I invest? Because I thought he's going to manufacture electric vehicle. He collected 800 crores. Thereafter, he tried electric vehicle, it didn't work. Are you able to understand? Now, he wants to get into software. But I didn't give money for software now. So, any contract entered into by the directors for software is beyond the scope of the memorandum and does not bind the company. So, anybody who has lent money on that cannot claim it from the company because it is ultra vires the memorandum. I am protected because I didn't lend to a software company. I lent only to a thing. Later on, when you come to amendment of object clause, you will see I can even walk out. That power is given to me. Before they amend the object, I can say I'm not interested in more. It's a very good protection for the investors. Remember, the purpose of company law is twofold: protect the investor, protect the creditor. Okay, agreed. Suppose Mr. A is a third party and has entered into a contract for supply of some services for a software. He can't collect. He cannot file a suit because the contract is void, ab initio. It cannot be ratified. Okay. You might ask me, sir, how does it protect the creditor? Baba, it protects the existing creditors. See, this new fellow has come, he is a fool. He lent for an activity which is beyond the scope of memorandum. Why should I protect him? He should have protected himself by verifying the memorandum. Whereas there are other creditors. So those are, and they are people who lent money for this company based on electric vehicle. We honestly believe you're going to make electric vehicle. So that fund, in case you go insolvent, these assets only I have for repayment. You can't use it for borrowing some other person. No. Are you able to understand? So it is protecting both investor or shareholder and creditor. Okay. So though sometimes, books also will say this is a trap for the unwary third party. Agreed. Many, even House of Lords has told. But still, Lord McNaughton's famous judgment in Ashbury Rail Carriage versus Rishi is what? This is what Lord McNaughton in the House of Lords said. The corporate life, I'm reading from this, the corporate life cannot be spent for any purpose other than those specified in the memorandum. See, they're all highly learned people. See the way he has written. The corporate life cannot be spent for any purpose other than those specified in memorandum. Unfortunately, fortunately, you and I do not have a memorandum. There is no object clause. You can do anything you want. You can always change your goals or develop better and newer goals. As you become older and older, develop better and better goals. Become the best version of yourself possible. If at all you ask me to define the goal of life, I will say slowly polish ourselves in such a way that we become the best version that we can ever become. In the Bible also it is said, you should live life so well and keep on polishing yourself that at one stage you are like a silver lamp or a plate of silver in which God can see his face. God's face will be reflected in you. That's it. You are God. you have achieved the real purpose of life. Where God can see himself in you, you can see him in you, and you can see you in him. That's it. Everything over. Okay. It's a gradual progression. Don't worry. You have a lot of time. 60 is also not. It will take more time. But that is where we are all going. So human beings' purpose is not restricted to memorandum. It is beyond. You can do anything you want with your life. Now, so the rationale is competency to enter all that I have explained to you. Main point is company shall not enter into a contract which is not in accordance with or for the purpose of the as mentioned in the main object of the company. Ashbury Rail Carriage was a case where there was a company that was engaged in manufacturing that was incorporated for manufacturing railway carriages, right? But they got a contract for laying a railway line in Belgium. They got a contract for laying a railway line in Belgium, for which they entered into a contract for purchasing coal and certain other matters. Now, that man tried, and the company went into liquidation. So in the liquidation, this Rish also joined. But the liquidator said, no, you didn't, this is not the main object. I will not validate this contract. The contract is void ab initio. That matter goes right up to House of Lords. And because at that time, there was no written company law. So the company law was being created. And the Ashbury Rail Carriage Company was decided by Lord McNaughton. Beautiful judgment. I read the entire judgment about 25 years ago. I read the entire judgment as a matter of interest. Very nice judgment. Chalo. So doctrine of ultra-vires. Let's see if you have any doubts on doctrine of ultra-vires. Thank you, sir. Thank you. So, yeah, so not necessarily ceremonial. Yeah, thank you. My father is very, very smart. In fact, there is another story. When I wanted to start practice, after I quit Pricewaterhouse, I came out, I had saved some money, but I needed 1 lakh. My father is a pretty wealthy man. I went to him and I asked him, Babaji, I need, of course, we don't say Babaji. In Tamil Nadu, we call Appa. Appa, I want 1 lakh. At that time, 1 lakh was the become. So he said, no, I can't give you. I can't give you. Then my mother got very angry. She said, he's your only son. He's also chartered accountant. He's a rank holder. Why don't you do something? He's struggling hard, that poor boy. You give him 1 lakh. Can you not spare 1 lakh? You're throwing money around, going abroad, enjoying life. Can you not give 1 lakh to this fellow? Father, finally, he was eating in, Thair Sadam in the house. He looked up at me and my mother and he said, okay, I will give him 1 lakh. 18%. I think some of you may not have understood. 18% interest. I paid. Okay, I paid. Nothing wrong. No, I have no regrets. My father taught me the value of money. Money doesn't grow on the tree. Today, my son also knows the value of money. He doesn't want to buy from me beyond what I have to give him. Other than that, he won't touch. He's from his own earnings only. He is paying. So, doctrine of ultra-vires power. No doctrine of constructive notice. Friends, doctrine of constructive notice you've already studied. I don't have to keep on repeating. What you need to understand that the doctrine of constructive notice is one side of a coin. If you want to understand the doctrine of indoor management, you have to understand doctrine of constructive notice. Doctrine of constructive notice is a rule of presumption. It is a presumption in favor of the company. I repeat, it is a rule of presumption in favor of the company that a third party proposing to deal with the company has read all the documents filed with the ROC. Got it? If I file with the ROC, my duty ends. Thereafter, the rule of presumption is that you have read it. Because constructive means deemed. Notice means knowledge. So, doctrine of constructive notice means deemed knowledge. You are deemed, that person is deemed to have knowledge. Even I don't actually have it. That's why deemed, yeah. If it is not there also, it is presumed that you have it. The word deemed is very, very, very powerful. If you see it anywhere in the law, immediately become alert. Because deeming provision, it's called deeming provision. In income tax, you'll find lot of deeming provisions. The law creates legal fiction. Deeming provision is a legal fiction. What is not there is being stated as there. That is why we call it legal fiction. Fiction means that which is not real, that which is not fact. Here, law is creating a fiction. Even though that Buddha has not read the memorandum, the law says, once it is filed, once it is uploaded, thou shalt have knowledge. Thou shalt deem to be having knowledge. Okay? He cannot, therefore, he is expected to know what the company can and cannot do. So, without reading memorandum, which is why most banks, lenders, etc., if whenever they receive an application, even if they are happy with the project, they want to lend money to the company, they will hire a company secretary to go to the MCA records and completely take out the documents. Complete report. It will be 200 pages. When I am auditing banks, I will go through that report to see whether the company has verified whether these are all, whether the company had the power to borrow, whether this is something that the company could have done. All that I will see to verify whether the sanctioned loan was within the limit, within the scope. Okay, so they will get a report from the company secretary, through a company secretary, for which they will pay very high amount. It's a very lucrative activity. For even chartered accountants could have taken it up, but we didn't bother. Company secretaries are minting money. Just they will go, download, pay some money, download all the forms, go through it, prepare a nice report, attach all this, create 200 pages of thing, and spiral bind it, and send it to the bank. 1.5 lakhs, 2 lakhs, straight away. Shamelessly, they will send a bill. Bank also, obviously, they won't pay. They will debit it to the applicant. Okay, that's the point. Why I'm giving this practical point is, how you may ask me, sir, how do I know, sir? Best way is to get a company secretary to do it for me. Including, later on, you'll be seeing charges. Later on, somebody will teach you, or anybody will teach you charges. Now, there also you'll find any charge which is filed with the registrar is a public information. That also. So if any property of the company is offered as security, that information also will be there. That also they will give. More about it when, if at all I teach charges, I will tell you. So basically, doctrine of constructive notice is all pervasive. Right, sir? It is a presumption in favor of the company against the third party. Doctrine of indoor management is a presumption. In favor of the third party against the company. In favor of the third party against the company. Are you able to understand? See, friends, I will give an example. Simple. The company has an articles of association. In fact, that is the case in Loyal British Bank versus Turkan. Okay. This doctrine of indoor management is known as Turkan's rule. If you know the facts, you will understand easily. In this case, the company had powers to borrow money, provided a proper resolution was passed. The company borrowed money and issued bonds. Bonds means promissory note or debenture or whatever. Okay, that is not the point. Point is company borrowed money. The resolution was not in fact passed. See, what the bank would have done, Royal British Bank would have done, they would have gone through the articles, which they can, and they have. And there they find a proper resolution has passed. No, they will ask the company, have you passed the resolution? Company says, yes, we have. Maybe they will give a copy saying resolution. But the resolution was not in fact passed. What can I do? Boss, I cannot come indoor. I cannot come into your company's building and find out whether you actually passed or not. I have to go by what you say. I have asked you whether you passed the resolution. That is my duty over. And you also have taken a written commitment from you that it was passed. You forged it, you did some nonsense, that is not my problem. I am a third party. I have done my duty of verifying the articles and asking you, and you have given me an answer. That's all. Now on thereafter, you cannot come and say, that resolution was not actually passed. It's my problem. So in Royal British Bank versus Turkan, it was very clearly held that the company was bound. They cannot plead doctrine of constructive notice. See, what? Where is the doctrine of constructive notice? He saw the articles. He asked you. You told him it was passed. Then you say it was not passed. How is the bank bound? You got it? So the fact that the resolution was not passed did not affect the bank. The bank was bound to inspect the articles, which it did. Beyond that, they were neither bound nor entitled to look. Otherwise, it would take them indoor. That is, behind the closed doors of the company's boardroom. Actually, in this case, Royal British Bank versus Turkan, the word indoor was not used. But in Mahoney versus East Holliford Mining Company, the word itself was used. A similar case, the word itself was used. Again, by Lord McClendon, he said that is where he said to do so would take the third party behind the closed doors of the company's boardroom. It would take him indoor, which is not the intention of the law. So the doctrine of indoor management is a simple rule. Wherever something is stated has to be done, the outsider is presumed to have knowledge of the substantive and procedural aspect. Substantively, he has to see whether within the scope of the memorandum. Procedurally, he should see whether all procedures are there. Then he has to ask, have you complied with all the procedures? That's all. Beyond that, he need not do. So you can say the doctrine of indoor management is the exception of the doctrine of constructive notice. Knowledge is presumed, but whether it was done or not and all, I cannot go and verify. I can presume in my favor that he can presume in his own favor that things which ought to have been done regularly have been done regularly. Now, you have to be very, very careful. The doctrine of indoor management has 4 major exceptions. Okay? 4 major exceptions. And I hope it's all clear to you up to now. I'm going to have one question at the end, which I'm going to ask you. That will test whether you know or not. Exam level question I have prepared from a very recent example. Before that, let us see quickly the exceptions to the doctrine of indoor management. First, knowledge of irregularity. See, a person who knows that the procedure was not correctly complied, he himself cannot say doctrine of indoor management. Are you able to understand? Look at this example. See, when a person knows about the irregularity, it is idle. It is idle means it is useless. See, here the word idle it's beautifully used in English. The word idle here, sorry. The word idle here means useless. It is useless for him to claim that he has been presuming that things are rightly done. See, in this case, Howard versus Patent Ivory Company, the directors had power to borrow up to £1,000 on behalf of the company without the consent of the general meeting. Up to £1,000. Beyond that, they said you have to go to the general meeting. General meeting means they have to get the consent of the shareholders, because shareholders will give their approval in the general meeting. So they have to go to the shareholders. Now what happened? Note it, your honors, the directors themselves lent £3,500 to the company. They lent. The directors themselves lent 3,500. Whereas without getting the consent of the general body. Now, what do you think? Can they recover? Can they recover the £3,500? Quickly, any answer is okay. Can they recover £3,500? They have lent money, but without getting consent. They are the directors. Can they recover? No. Gunjan is right, but why? Later on, you are right. For that, you have to give answer like this. No. Because this is the first exception to the Doctrine. But suppose they are third party, they can be protected. Please note the difference, my dear friends. Please note it, your honors. If these directors are not directors, but rather some third party, Aam Aadmi, that fellow can claim, because he read the articles up to £1,000 beyond the general meeting. He asked these rascals, have you passed the general meeting resolution? These rascals also told, yes, we have. Then he lent it, then Tarkan. Straight away, Royal British Bank versus Tarkan. But here, who lent the money? Not some innocent Aam Aadmi like me who doesn't know anything. These are directors themselves. They lent, knowing that the procedure is not. So when they have knowledge of irregularity, Doctrine of Indoor Management will not apply. This is the first exception. So M could not claim the benefit of Tarkan's case. Sorry. The directors could not claim the benefit of rule in Tarkan. See, this Doctrine of Indoor Management is also called rule in Tarkan's case. Obviously, because the famous judgment is Royal British Bank versus Tarquand. See, Tarquand is a person. How he became the defendant, we don't bother. You understand? That would have been appeal, it would have changed. Don't bother. Who is Tarquand? Why Royal British Bank sued him and all? You don't. Why he did not? He might have been the liquidator. You understand? Don't worry about all that. If you read the entire case law, you will understand. It is reported. There is a beautiful book, Company Cases. You can get hold of some edition in your city. If any old bookshop is there, you go to be there. Or British Council Library. In fact, I got it from British Council Library. I borrowed it from the British Council Library and I took notes. Still, that notebook is there with my notes, which I had taken. Based on that, I wrote my BCom exam. Imagine the fellow who corrected my BCom company law paper, he himself would not have known that there is so much in this law. Sorry, those fellows, the university professors, what do they know? They don't know about the existence of company law. Forget teaching it. I'm justified in making this comment. In fact, I used to go to the many colleges where they will invite me for giving a lecture. Then I'll meet the HOD Commerce. No, at that time I'll tell him, sir, 2013 new law has come. He said, so sir, 2013 new law has come. That fellow will be asking in 2016. I'm asking, are you still teaching the old law? Yes, sir. University has not announced that. Sorry. Chalo, enjoy. Okay, so that is the problem. Sorry to make fun of the education system, but that's how it is. Luckily, our Board of Studies is putting edge. Any amendment, immediately they will amend the study material. Of course, 6 months rule is there for you. Don't worry. Only it will become applicable to the exam only 6 months later. But they will do research. The excellent faculty we have in the Board of Studies will do research. In the latest amendment, they will include in the study material. They will see to it that it is included. Okay, so Tarkan's case. Okay, they can't claim the benefit of the rule in Tarkan's case. Okay, now second exception. Purporting to act as directors. See, there's a slight difference. In this case, these fellows are actually directors. They were proper directors. But in this example, they need not be directors, but they are purporting, means acting or claiming that they are directors. They are not directors, they are claiming. Okay. So long as he has acted as a director, he cannot claim. Even if he is not a director, it is okay. He acted as a director now. See, look at this case. C's appointment as a director ceased. So C ceased to be a director. C is stopped. He is no longer a director. S was never appointed as a director. These two fellows, C and S, C who was no longer a director, S who was never appointed as director, purported, claimed, acted as if they are holding a board meeting and appointed M as director. Okay. See, think about that M, yeah. What a fellow he is, huh? Then all the three, including this new M director, they allotted shares to M. So what is M doing? M is acting as a director here. Agreed, he is a third party. But at the time of allotment of shares, what was M? M himself says, I'm a director. Now later on, it transpires that allotment is invalid. And that is, these fellows said, no, it's not like that. Then M filed a suit and said, I am eligible for compensation. He said, court said, how? Because, no, I'm a third party, I'm innocent, I'm protected. Yes. No. Boss, you should be a real third party. Whereas in this transaction, you are very much inside the boardroom. How can I say doctrine of indoor management? You are very much inside. You are acting as a director, or at least purporting to act as a director. Got it? Therefore, you do not have the benefit of ruling Tarkan's case. This is the decision of the court. He was an insider. The knowledge of irregularity was important. So that is why in your institute material, you will find these two are combined. Knowledge of irregularity and purporting to act as director will be combined. But be careful, purporting to act as director is a situation where he need not be a director. This purporting to act, claiming to be a director. The exception number 3 is forgery. Forgery is a nullity in law. It's a very important doctrine, sir. Forgery is a nullity in law. No man can claim a benefit from a forgery. And it is the duty of the banker to protect the client. If a forgery comes to him, the banker should not honor the check. The banker should have a mechanism by which he will detect the forgery. And believe me, there are, sir, even the most extraordinarily good forgery, by seeing it, we will know, sir. Sir, I have myself detected, sir, in forensic audit. The minute we'll see, I have called the director and I told, sir, this signature is not your signature. No, it is my signature. Or somebody else will say, it's not his signature. How do you say? Show me your regular signature. Then I will show him 15 differences in angle, in pressure, in curvature, in the way an alphabet is written here and the way he normally writes it. I'll take about 5 of his normal signatures and these bogus signatures. And I'll tell him, sir, there's a forgery, sir. You got my point. Forgery is not so difficult to find out. It's easy to find it. Of course, there are some really, but even then bankers are taught. Okay, even if you don't, I'm unable to prove that it is a forgery, my suspicion will be aroused. Something is wrong with the signature, like that. So a presumption cannot convert a forgery into a genuine transaction. So when forgery is used, the company cannot say, the third party cannot say, I'm third party. Say, you are a third party. Procedures, whether it was happened or not, you cannot find out. But when a document comes to you with a signature, you jolly well have the duty to verify it. Okay. So a secretary of the company, secretary means the company secretary only, forged the signatures of the directors and issued share certificates. Are you able to understand? Now a transferee claimed damages from the company on the ground that the company was stopped from denying the truth of the certificate. Is a doctrine of indoor management. How do I know it's a forgery like that? But in Rubin versus Great Fingal, was very clearly said, company is not liable. An outsider dealing with the company has to presume that the company has ostensible authority. But he cannot presume that the secretary has ostensible authority to forge share certificates. Forgery is beyond any ostensible. Ostensible means apparent. Yeah, secretary has the authority to issue share certificates. But not to forge. I'm a third party. How can I know forgery? Forgery, so I should verify whether this. So how to do it? I have to verify with some other signatures and verify and then only. Okay. So forgery can never become genuine. You cannot justify a forgery through doctrine of forgery. The minute you say a forgery, the third party is has to protect. He has to ensure that he took care. Okay. Lastly, persons put on inquiry. See, when my suspicions are aroused, I have to investigate. This is true for an auditor also. Even without your company law amendment, blah blah, Satyam and all that, we were always under a genuine. See, definitely, you see, when something is so suspicious, I can't say I'm a statutory auditor. I'm only auditing balance sheet. No, I have to investigate. So he ought to investigate. Or any person whose suspicion is aroused has to investigate. If he fails to investigate, he cannot presume in his own favor and say doctrine of indoor management. Hey, how do I know or not? No. So things, in English, we have a phrase, an idiomatic phrase which says something smells fishy. There's a fishy smell. Something smells fishy. That means there's something wrong here. I'm not able to say what it is, but there's something wrong here. So I have to make further inquiry. That inquiry could have shown what they are. You can't simply say, no, it's okay. Later. See, take the example. In AL Underwood versus Bank of Liverpool, a sole governing director of a company paid checks drawn in favor of the company into his own account. Think about it here. Consistently, this fellow is coming to the bank. He is the sole governing director. On behalf of the company, is endorsing the check in his personal name and he's depositing it. Of course, this cannot be done if it is an account pay check. Assuming that those checks were not account pay. Because if it is an account pay check, he cannot do that. But if it is a non-account pay check, he can. Being a director, he has the ostensible authority. He can endorse it in his own name and deposit it in his account. Correct. But if he keeps on doing it, the banker has to ask, hey, you are running a company. Why you are depositing in your own account? Why don't you deposit it in the company's account? So that inquiry, it's called persons put on inquiry. Your honors will note, this is not enquiry. This is inquiry. See, you meet your friend in the metro or in the road and you ask him, hi, how are you? That is an inquiry, Enqi, inquiry. How are you? He will say, I am fine, I am not fine, whatever. This is inquiry. The CBI will take the MD of the company and put him in a room and inquire. Inquiry. Inquiry is tough. They'll ask all sorts of uncomfortable questions. Okay? Right. That's again a very, very subtle difference in inquiry and inquiry. Okay? You go to some company or say, or some railway station, there you will find inquiries, not inquiry, inquiry. Where you can go and ask, when will the train come? Kab aayega, when it will come? Like that. You can ask. Okay. So, persons put on inquiry cannot claim the benefit of the turquoise. Friends, this is a fresh, new question set by me. This incident happened very recently in my own practice. Of course, names are hidden, concealed, but it happened. That the directors were sitting in front of me asking what to do, whether the company is bound to pay the loan. If the thing. So you have to advise. Literally, I advise them on this. This is not something theoretical exam, some book problem. My own practice, I advised. Not 20 years ago, last week. So kindly answer. So don't think doctrine of indoor management is some old British concept. It is not relevant now. It's still relevant. Yeah, I will give you 2 minutes to read and answer. So Novice VR Private Limited is a startup company incorporated on 8/4/2024. hot water. Engaged in developing virtual reality solutions, whatever that is, some cutting edge. Company was doing well, but had heavy cash crunch. Just information. As per the articles of association, borrowings beyond rupees 1 crore required a board resolution. The managing director, Mr. DVS, approached a private finance company and borrowed 2 crores. He submitted a document purporting to be, claiming to be the minutes of a board meeting. The minute you see purporting, it means that we don't know the reality. He's saying it is held at Hyderabad on 2/7/2025. No such board meeting took place. The reality, the back board meeting did not take place. The finance company lent the amount in the name of the company, but on the request of Mr. DVS, noted your honors, on the request of Mr. DVS, credited his personal bank account. See, the loan is sanctioned in the name of the company. Lend it to the company, but credited to the personal bank account of DVS. And the EMI was also taken from that account. Later, Mr. DVS quit the company and absconded. The bank is now, sorry, not the bank. The finance company is now proposing to proceed against. Sorry. So sorry. It's not the finance bank. It's the. Okay, you people are all. You like abbreviation, no? Finco. Finance company. Finco. Younger generation likes abbreviation, right? Modi ji also likes abbreviation. Full word should never be told. Full thing should never be told. So the Finco is now proposing to proceed against Novice VR Private. Will it succeed? Caveman loss. It is really bad. Caveman loss. Correct. They will not succeed because this is clearly an exception to the doctrine of indoor management. Yeah, but can one of you, not forgery. Deepika ji, it is not forgery. There is no forgery here. See, because he is the MD. And as MD, you know what he's doing? He is giving a document saying board meeting held on so-and-so date. Such a resolution was passed. He is signing as MD. There is no forgery here. This is coming under a different exception. Which exception will come here? Not forgery. There is no forgery here. Not negligence. Yeah, in a way negligence, but I would prefer Jaya Manocha's person put on inquiry. The finance company is a person put on inquiry. Similar to the Royal British Bank versus Underwood. Underwood versus Bank of Liverpool. The bank is put on inquiry. Similarly, the finance company, the Finco, is put on inquiry. Hey, boss, you are talking KYC, this, that. Srikanth, you are strangling him with your KYC. He wants to borrow 1 crore also. You are telling, who give me this proof, that proof, everything. If I'm borrowing from my company, will they allow me to put it in my. That is all end of story. I'll be arrested. And my CIBIL score will become negative. But see, for Mr. DVS, how beautifully they are doing. He will borrow from in the name of the company. And then they will debit his account. They credit his account. And EMI also will be taken from his account. Wow. Gross violation of, in a way, I'm even asking the directors to proceed against the Finco for collusive fraud. That is a different legal remedy. Point is, they cannot file a suit in recover. Because, boss, you are put on inquiry when DVS said, give it in my account. You should not have given. You should have called up the other directors. You should have asked, what's happening here? Does DVS have the power to take it in his own account? Like that. So put on inquiry is the correct answer. Okay. No, Anubhav, I think you have to be more careful. Abhinav, you have to be more careful in your answers. This has nothing to do with beyond its powers. The borrowing is not beyond the powers. Suppose it had been done correctly by passing a resolution, it is perfectly valid. But even then, The amount cannot be deposited. At that time, what the finance company should have done, it should have taken a letter of undertaking from all the directors that they have no objection to the amount being credited to Mr. DVS. So the finance company has acted to an extent with gross negligence. But more than that, they are put on inquiry. Therefore, they cannot claim the doctrine of indoor management. Okay. Be careful while writing answers in the exam. Institute expectation is completely well-argued answers with some case law reference if possible. So you can give an A.L. Underwood versus Bank of Liverpool. Now, in some case laws, there will be some things like this. Am I correct? Some things like this. Should I remember all this? No. Only the name. No need. If you remember all this, seriously, you are a really guardian. Okay. So this is the main doctrines, 3 doctrines. Quickly, we'll run through the remaining portion. Alteration of articles. Alteration of articles requires a special resolution. That's all. Okay. Special resolution. Let's see any doubts are there. Correct. Mustafa is right. Mr. DVS did fraud. Absolutely. I know Mr. DVS is known to me by another name. I know that fellow. What to do? It's not a fraud. Oh, it's a fraud. Because he's taking in another company in his account. Actually, in my example, he didn't abscond. It's still available. Inquiry is going on. But I wanted to give some little more flavor to the question. It's a little more masala. So I put abscond. See, because they see dishes, we like more masala. We are not like the British. They like it bland, maximum pepper. But we like our food spicy. Am I correct? So our stories have to be spicy stories. So absconding only will make it more spicy. DVS has not come to me, sir. I will not take DVS, sir. Sorry. The other directors have come to me with the matter and they have asked me for my opinion. I am giving the opinion. Believe me, some of the questions asked in the exam are presuming that you as a future chartered accountant would be approached by such clients or by such company director who is your boss, MD, and he will ask you to advise him. So the answer you are going to give is nothing but the reply you will give to the MD. Okay. So I will, DVS I will not touch. No way. See, there are some things are not negotiable, Baba. I don't deal with frauds. I don't help frauds. No way. Okay. No way. If at all DVS comes to me and says what to do, I will tell him, first of all, you refund the entire loan back to the finance company, close the loan. Completely close the loan. Finish it. Okay. Then go to your directors, make a call for a board meeting, tender an abject apology for what you did, maybe give your explanation, etc. That's all. But even then, the other directors have the right. See, in this case, as of today, there is no damage because DVS was paying the loan from his account correctly. But that is no justification. That is no justification. So I will tell him, you pay the entire amount now itself. Close the loan. Clear it. Then come. Then only you have to talk. And they give a written confirmation that you have done it, it is wrong, or whatever. And let it be documented. Okay, then only that. So, then maybe I can convince the other directors not to proceed against you for criminal act. Maybe I will advise them, don't do it. Let it go with this, with a warning, whatever. In fact, I have given them 3 options. One is to proceed in the court. And the better option is what I've told them is go for a complaint against him to the regional director for mismanagement of the company. Because he was having control of the company's affairs. So that's again not in your syllabus. In final syllabus, there is an application to the tribunal. But before that, we have to go to the RD. So I told them at first level, you go to the RD and file a complaint. If anything, then the RD himself may pass an order. Otherwise, you go to the tribunal. Okay. So if you want to alter the article, special resolution. Okay. But be careful. One type of alteration needs approval. What is that? When you want to remove the word private. Okay. We'll come to that later. But right now, you want to alter the name. You have one name. You want to alter the name. First, you have to pass a special resolution for alteration of the memorandum. Then you have to obtain the approval of the central government in writing by making an application in form INC 24. Normally, they will do it. Okay. But suppose the only change in the name of the company is the deletion or addition of private on account of conversion from one class to another. See, conversion from one class to another, you would have studied it, hopefully in preliminary. So it's only a matter of conversion, or maybe we'll see it now. If it's only a matter of conversion from private to public or public to private, only the addition or deletion of the word private, as the case may be, then no need for approval of central government. But if you want to change the name itself, currently the name of the company is Dubacor Limited. You want to change it to Manar and Company Limited. Okay, you have to first pass a special resolution, then obtain the approval of the central government in writing. You have to make an application in INC 24. Then the registrar will enter it in the register of companies in the fresh name, and the fresh certificate of incorporation will be given. Okay, got it? The change of name shall not be allowed to a company which has not filed annual returns or financial statements due for filing with the registrar, or which has failed to pay or repay matured deposits or debentures or interest thereon. So, if a company is in default of filing annual return, you'll see that when you come to management and administration. Similarly, financial statement, you'll see that when you come to accounts of company. And if in case it has not paid or repaid matured deposits or debentures or interest, such a company cannot change its name. See, in the exam, what they will do now, they will say, so-and-so company wants to change its name, advise the procedure. Also, B, they will say, what will your answer be if you are informed that the company has not paid the matured deposits? Then you have to say, in that case, the company shall not be allowed to change its name unless it has repaid or paid the matured deposits. So once it makes good the default, it can come. Okay. This is for alteration of name. Friends, there are two things that I want to tell you. Firstly, in the last class, I saw one comment in the chat box. I forget who made it, which said that Section 8 company cannot be holding company or subsidiary company. There was a comment in the chat box which said Section 8 company cannot be holding or subsidiary. There is no such provision in the Companies Act. I don't know where that person got the idea. Okay. So kindly do not think. See, a private company, which is a holding company or a subsidiary of a public company, cannot be a small company. Also, Section 8 company cannot be a small company. Section 8 company cannot become a small company. Okay, small company definition may have. Now, maybe that person or lady got confused with that. So, again, for the removal of doubt, so that none of you should go to bed thinking that Section 8 company cannot be holding or subsidiary. It can. Section 8 company can be a holding company. Section 8 company can be a subsidiary also. Okay, please, if you have iota of doubt, please remove it. I didn't answer yesterday because the other class because I had a slight doubt. Maybe there is some, because this Ministry of Corporate Affairs is one of the worst fellows in the whole world. They will quietly release one circular and keep quiet. So I verified everything, the entire nothing. There's no circular, no notification, section by nothing. Okay, so please don't confuse. Don't confuse yourself. Don't confuse others. First step, don't confuse yourself. Be clear. Then with that clarity, the other day, one gentleman in an association I know, he was giving advice to two other younger people. And I called him, you yourself are not clear why you are giving education to them. I bombasted him. Sometimes I can be very tough also. What to do? Not because I don't like people, but because I want everything to be accurate. Okay, so then he himself said, I said, look here, if you know, you tell. If you don't know, just keep quiet, come to me, I will explain. You learn, then you go and tell them. Okay, this is what I said. Don't presume and do something. And in the Kathopanishad, you know what beautifully it said, na? Naiva andhaniyamana. The blind leading the blind, both shall fall into the ditch. So don't do that. So no problem. So that is one point. Secondly, I want to show you one document, which will be, it is a document. I'm sorry. Yes. This is the certificate of incorporation of a company whose name has been altered. Okay, I'll be very frank. This is my own consulting company because I don't want to show some client data. Yeah? I can't show. This is a confidential. How can I show you a client data? So I'm showing you my own company. Not my means not my company owned by my wife and her sister, which does consulting. They hire me for doing consulting work. When they want consulting, they get consulting assignment, they hire me and I give consulting. Not income tax and company law. That I do in my firm, Karpagam Krishna Natarajan. Why I need productivity consulting, strategic consulting, such work we do in. We used to do in Blue Dot Consulting Solutions. But now the name has been changed to Prometheus Consulting. So this is that certificate of incorporation. I just wanted to see a real document. I said I will show you. So it is digitally signed by one Mr. Joseph Jackson, Registrar of Companies. Okay. So I hereby certify that the name of the company has been changed from Blue Dot Consulting to Prometheus Consulting Solutions Private Limited, with effect from the date of this certificate, and that company is limited by shares. Company was originally incorporated with the name. So clear. Just to show you how change of alteration of name. Now, for that, can you see Form INC 24? This is Form INC 24. Hey, not a big thing, yeah. Don't think farm and all. That we can hire a company secretary to do. You and I need not do, yeah. We should not waste our time doing all this. I mean, as an article clerk, you might have to do. Once you become a member and all, don't waste your time. Uploading farm, blah, and okay. That is not your job. Just broadly. See, once that MGT 14, do you remember MGT 14? This is the form that is to be filed whenever you pass a special resolution. Okay. So for that, they would have filed MGT 14 now. At that time, when SRN would be generated. That SRN reference you have to give here. And date of passing of this. You remember now, if you want to amend the name, what you should do? First, special resolution. Now, that special resolution, you have to give reference. Okay. All that number of members, only 2. And etc., etc., etc. Okay. And this is digitally signed using one of the directors. It so happens my wife's digital signature. She's a director of that company. Okay. Now, say I'm showing you my own company, ma, because I can't show you some other company, ma. That will violate client confidentiality. Okay. Blue Dot is not my client. So obviously, I can't be the auditor. Yeah. My wife is a director, or I can be auditor. Somebody else is the auditor. I don't know. Okay. So these are all, this is INC, this is MGT 14. Whenever you pass a special resolution, you have to file MGT 14 within 30 days. Okay, this is the sin of the company, not SIN sin. This is CIN sin. Okay. Then, just more for, so subject matter of the resolution to change the name. Also, the resolution copy will be attached. Okay. So what all you're attaching will be given. Got it? A name approval letter, because the new name should be approved. No? Actually, the name Prometheus Consulting, we couldn't get. But finally, we proved that that company was, the other company was defunct. So we wrote a letter and then they cancelled that. That is, they removed it and then allotted to us. The name, they said this is an existing company. He said, no, that company is defunct now. How long you are going to keep that name? So like that we have done. And so this is the notice. Later on, if at all I do management and administration, I will show you this and explain to you. So when you do management, everything will become relevant to you. The resolution, then because it is special business, the what do you call it? Notes. All these notes will become relevant at that time. Also, because it is special business, we have to give statement pursuant to section 101, explaining what it is. I'm just showing this. It's a huge set of documents. I'm just showing you what is relevant. So I'll try to see if memorandum also is there in this. Memorandum also could be there. I can show you. Is there somewhere? It's not a big deal. Memorandum. See, this is the memorandum of association. Can you see? This is the memorandum of association. Now the new name. We have to file it with the new name. Once the name is changed, we have to file a fresh memorandum giving the new name. So the clause number 1 is the name of the company is. And then the register of the company will be state of Tamil Nadu. Third, the main objects, management consultancy services. Okay. And like that. Okay. See, the company's name has not yet been approved. Therefore, the old name only is used, not the new name. Once the name is approved, thereafter we will change the letterhead, seal, everything will be changed. It is changed. Okay, including we'll inform the bank, everything will be changed. So these are the ancillary objects. The objects for carrying on the main objects. Matters which are necessary for furtherance of the object specified. Okay. Then, of course, you have the, but a lot of items are there, na? Lend, borrow, all that. Okay. Everything and anything that you have to do will be covered in this. I'm sorry, I'm going a little fast. Fourth, liability of the members is limited to the amount, if any, unpaid, if any, on the shares held by them. Authorized capital, 1 lakh, whatever. Sixth is the association clause. We, the persons whose names and addresses are hereunto subscribed, are desirous of being formed into a company. Okay. So the old memorandum has been entirely replaced. Similarly, the articles also we have, wherein again the name has to be changed. Everywhere you have to change. Okay. See, private company, you remember the 3 matters it has to provide. Okay. 3 matters you have to provide that. Anyway, so with this, I thought I would share some stuff with you that could be of some relevance to you. And let's see if you have any queries. Karpagam Associate, no. My firm is called Karpagam, Krishnan and Natarajan. There is one more firm in Chennai called Karpagam Associates, for your information. Ours is Karpagam, Krishnan and Natarajan. That Karpagam is not the name of any relative, etc. It is the name of the goddess Karpagam, but he is in Mylapore. It's the original name of the goddess, by which in 70s you could have a name with such names could be there in 70s when we were formed. Now you cannot. Now you cannot have Ma Santoshi like that. Now you cannot. But in those days we called Karpagam and Co. Then we merged and became Karpagam, Krishnan and Natarajan. Absolutely. The memorandum of association is as per table A. Okay, it's as per table A. In memorandum, you cannot adopt a table A. You have to, as per the format, you have to write. See, in this subject, I cannot do it, Mr. Abhinav. Later on, not today. See, you should also be a little more considerate. When the topic share capital and debentures coming at that time. One more thing, today, yeah, as per F only. Articles is Pakka F. No change. Only F. So if this articles will be based on F. Means we have taken F and put it here. So with the changes, you obviously name of the company you have to put. Huh? Okay, in F, name won't be there now. Okay, so share certificate now we'll do it when you come to share capital and debentures. Okay. When the topic share capital debentures, if I'm taking it, if at all, I will show. Definitely. When the relevant is will show. I can't show without relevance. Just because you want to see, we cannot do it. Okay. Remember that you're attending a public class, not a private, personal one-to-one private tuition. Maybe I can show. Even then, I wouldn't show because the student should be told the subject in a sequence. And the student should have the patience to wait for that topic. Well, he will be given that knowledge. Okay. Even if it is one-to-one, I am teaching Amina Vishra. As a teacher, I know when to give the knowledge, at what time to give the knowledge. You should be ready to take it only at that time. I am a very, very traditional, old-fashioned teacher, and that is the best way to teach. Just because of generation gap and all, if somebody is doing some nonsense, they are doing injustice to the student. Believe me when I say that. I will not pander to the student. I know what my knowledge. I know how to give it to you. Ready to receive the knowledge. Thereafter, you can, till such time, don't let the vessel not dictate how the water is to be poured. They know how to pour the water. Don't worry about it. I mean, this is not told with arrogance. It's told with genuine confidence. As a teacher with more than 30 years experience, I'm telling you, I know how to coolly get this knowledge to you. Just aram se sit back and take it. As it comes to you in the way I'm giving it. Beyond that, believe me, there is nothing much. Easily hundreds of students across the country have told me, sir, we listened to your lecture. I got 45. I got 56. I got 65 on their thing. Okay, whatever it is, I'm happy, sir. Thank you. So don't worry. I have confidence. I will do whenever I want. Now we move on to another topic, which is rectification. Rectification. Are you able to understand? Rectification. That means the name already given is identical with, due to inadvertence, means mistake, or otherwise, a company has been incorporated with a name which too nearly resembles the name of another company. Now the central government, in this case, central government means regional director. Central government means regional director. Most of the time, I will tell you, I will give the data. But if you have a doubt, believe me, most 98% central government means regional director. Regional director. Who is the registrar's boss? We'll be seeing RD in change of registrar office also. So if through inadvertence or otherwise, a company on its first registration or on its registration by a new name, either case, first registration or new name, is registered by a name which in the opinion of the central government, go here, is identical with or too nearly resembles the name by which a company, see the two is there in the section. English language, the way I learned it, that two is wrong. Resembles two is a wrong English, but it is there in the section. Bad grammar, but there in the section. I am therefore not responsible for it, but I am giving it there. The correct English is identical with or truly resembles the name by which a company. The two is there in the section. If you want to write it, you write it. Bad English. That's not the way I learned English. Okay. So is identical with or too nearly resembles the name by which. See that this is resemble to is a typical Indian mistake in grammar. See the preposition wrong because of vernacular translations. That's why. They think in vernacular and translate in English. That's a problem. They can't think in English. So, in the opinion of central government, is identical with or too nearly resembles, okay, to the name by which a company in existence had been previously registered. Okay, simple ma. The company is already incorporated or changed name. Now that name or the new name is identical with or similar to the existing company ka naam. Or, in the opinion of the central government, is identical with or too nearly resembles an existing trademark. Trademark also covered here, which is why before allotting name, the registrar of companies, MCNA, they will review the trademarks registry. See, today, both the register of companies and the register of marks is a public document online. You can search online. So they will do a quick search to ensure that whether obviously you are resembling any brand. Sort of, they'll make a cursory. So obviously, if it is that, they'll say, hey, trademark is there, go and get his thing. Okay. But if they miss it, also no problem. That's why they say if through inadvertence or otherwise, I missed it, it's not my problem. You are the brand owner, now you object. So the brand owner has to make an application within 3 years of incorporation or registration of change of name. So 3 years is given. Beyond 3 years, if the trademark owner is keeping quiet, he cannot do anything. Okay. But believe me, most trademarks have been registered now. A lawyer will be engaged to monitor. For example, I have registered Blue Dot. Blue Dot is the name of another company that we have in the group, which is registered trademark. And my lawyers, every time they will look now. And as the client, I pay them an annual fee, for which they will see to it that if some other company tries to register Blue Dot, they will immediately object. Straight away, they'll object. Okay. So within 3 years, that objection has to come. If so, then the central government, once this is coming now, then the central government may direct the company to change its name. And the company shall change. Your Honors will please note the word shall means mandatory within a period of 3 months from the issue of direction after adopting an ordinary resolution. God only knows why they included ordinary resolution. After all, you have the power to direct him. And you have told he shall change. Why pass resolution? And see, there is a small technical problem here. I don't have time to explain it, but quickly I'll tell you. Resolution means suppose the members don't vote, what happens? That is why they have a solution here. They say, boss, you pass an order resolution and try to do it. Otherwise, we know what to do. So they will ask them to do it within a period of 3 months. Ladies and gentlemen, whatever is given in study material, this is correct, this is correct, this is correct. Okay. And the notice of change of name to be given to ROC with order of CG. Then the ROC to carry out the necessary changes in the certificate of incorporation and the memorandum of association. Suppose there is any default in compliance with this direction under section 16, then company fine of 1,000 for every day during which the default continues to 1 lakh. Every officer in default fine which shall not be less than 5,000 rupees up to 1 lakh. Okay. Now, suppose they say you pass an order resolution. Company is passing an order resolution, but not able to pass. The members are not passing. What can I do? Then the central government itself will change the name and will allot a new name. It will decide some new name. Okay. It will decide some new name. Pathetic Limited, whatever, and give it. Because we gave you option, yeah. You said you shall change. We told you, you pass an order, change your name. You have not done it. No, I will change it for you. Henceforth, you are going to be known as Pathetic Limited. Go. Unfortunate Limited. Go. Okay. Thereupon, that new name will be entered. And that will be the name of the company. If they want, they can change it themselves later on. But that new name should not be a name which is that same old name. Okay. The company will not be allowed to change back to the earlier name. No. Okay. Some other name. Some other name. So this rectification of name is to protect companies that are registered with their name to prevent misuse of their name. That's all. It's a very interesting provision. Now we'll go to registered office. Now, must and shall are one and the same, sir. The words must and shall do not have the more legal term is shall, sir. If you want to be legal, you will use shall, sir. Must in conversation, you can say, sir. When I am telling somebody, you must do it, sir. So I am advising a client. And so in law, we use only shall and may. If the law says you may do it, it means you have a choice, you have an option. You may means may not. May includes may not. Shall, mandatory, no option. That is the general meaning. Must have never seen in the law. It is not a very, what to say, a nice word, professional word. In conversation, you can use. I don't care what you do, you must go. It's okay. Or I can tell my colleague, I don't know what you do. You must finish it in 3 days. Must. Or there I won't use the word, you shall finish it in. That will be too pompous. Yeah, I'm High Court, I'm passing an order. So legal documents generally use the word shall. They may use the word may. When they use the word may, that means option. You may. Option. Okay. Ashma Mishra, you are the owner of a brand. You have registered the brand. Now another person is incorporating a company. The name of the company is identical with your brand. See, suppose you have a brand, okay, Vapor Rub, something like that. Now they are forming a company, Vapor Rub, whatever. No, it's exact word they're using, or maybe similar word they're using. Are you able to understand? No, you are the owner of the brand. Now it is your job to constantly look at the register of marks every time the new gazette comes. You have to see who are all. Similarly, you have to scan the register of companies application. Who are all companies being incorporated. If anybody is coming out with your own, the name of your brand, you have to make an application to the registrar. But you have to do it within 3 years. 3 years is given as a period of limitation. See, I can't keep on waiting for you to file a complaint. Maximum 3 years. If within 3 years you do not file a complaint or you do not come to the RD, then sorry, you cannot come again. Maybe thereafter, this route is not available to you. Your Honors, please note it. This route is not available to you. You cannot apply to the registrar and the registrar will not direct. But you can still go to High Court. You can file a suit for passing off. So many other legal remedies are there to you under the Trademarks Act. But under the Companies Act, you cannot come beyond 3 years. I hope I have explained it to you, sir. Have you understood, sir? Just give a confirmation that if you have understood, or else you have to ask a very specific question as to what you don't understand. But kindly confirm if you have understood it. So, registered office. Now, please note it, Your Honors, the company can have any number of, thank you, Mr. Arsh. Thank you. The company can have any number of offices, ma'am. You can have corporate office, you can have this office, that office. But registered office only one. Because that is the office. It's a physical office where the corporation or company will receive the service of legal documents. Suppose police wants to send an arrest warrant, or the court wants to send a notice, or the registrar wants to send a notice, or I am a plaintiff, I want to file a suit against you, and I want to send you a copy of the plaint. All that should be sent. Note it, Your Honors, shall be sent, must be sent, should be sent only to the registered office. If it is sent to any other office, it is not valid service. Later on, we'll see service of notice. Maybe you saw it already in preliminary, whatever. Valid service means it has to be served on the registered office, not on any other office. So therefore, the registered office address should be informed to the registrar within 30 days. It should not be a PO box. It must be a physical location where some human being is present. It cannot, see, you can have virtual blah, blah, blah. But for the Companies Act, you should have one physical office in where I can go and give it. And somebody should be there to receive it. If nobody is there, then I will paste it on the wall and come. I'm allowed to do it. Okay. So it could be different from head office, corporate office, blah, blah. It is called registered office. The domicile and nationality of the company is determined by the registered office. So wherever the registered office is there, that is where the domicile. So if I want to ask you, what is your domicile? Where is your registered office? Sir, our registered office is in Ludhiana, sir. Oh, then your domicile is Punjab and Haryana, Punjab. I know that. Okay, which many things will follow from that, sir. If I have to file a suit, civil suit, I can file it either. See, if I want to file a suit against you, you are the defendant. Now the Civil Procedure Code says suit should be filed either where the defendant resides or where the cause of action arises. So many people in the invoice, you might have noticed, all suits under this invoice are subject to the jurisdiction of the whatever, Indore High Court, Madhya Pradesh High Court, whatever. Got it? In which case, if I want to file a suit, I have to file only in Madhya Pradesh High Court. I can't file anywhere and everywhere. Okay. So if nothing is mentioned also, if your registered office in Ludhiana, I have to file it in Punjab and Haryana, maybe Chandigarh or Ludhiana if you have a bench, Ludhiana bench. Or no, why? The first class magistrate having jurisdiction over Ludhiana. There will be a first class magistrate having jurisdiction over Ludhiana. In his court, I have to file the plaint first. Not the Punjab and Haryana. Are you able to understand? Even suits are determined by domicile. Therefore, it is very important. That's what I said. It is also important for determining the jurisdiction of the court. Which court has the right to take up the case? Suppose the company's registered office in Coimbatore, you cannot file a suit in Mumbai, boss. You have to come to Coimbatore and file. Okay. In fact, one company, we wanted to file insolvency petition against one company. The registered office is in Mumbai. We filed in Mumbai only. Tribunal Mumbai only we have to file. I can't file it there because my registered office is in Chennai. I cannot file it in Madras Tribunal. I have to come to Bombay and file. Okay. So that is why this registered office becomes very, very important. So within 30 days, you have to file the information about the registered office. Got it? But obviously now, the minute you are incorporated, how you can have. So you need to locate a place, convince the landlord, lease agreement, blah, blah. So 30 days. Company shall furnish the registrar verification of his registered office within a period of 30 days in form INC 22. Should I remember form number? Whatever is given in the study material, please remember. If it is not in the study material, chhod dijiye. But if it is in the study material, please remember. Okay, please. Humble request. Notice of every change of the situation of the registered office after the date of incorporation shall be given within 30 days. Again, INC 22. Even if you change the registered office, you have to give. But be careful, changing the registered office, there are many, many ways. Okay, we'll explore all that and then we will decide. Green tea. Green tea. So, now, this is not very important. I'm going to skip it. Basically, it says the registered office name should be affixed outside the building. It should be given in the letterhead, in the checks, everywhere. The name of the company should be clearly mentioned. If the name of the company is not mentioned, then the company is not bound. The directors become personally liable. Not in this section. It is there in final syllabus. Where the directors do not mention the name of the company and the registered office, etc., then the company is not bound. Because, boss, where is the proof that it is in my name? Got it? In fact, in this example, the devious example, the first thing I asked them was, please check with the finance company whether the letterhead of the company was used or whether he simply signed something and did it. Because if not, if the name of the company was not used, merely he gave the PAN number somewhere and did some bogus. No, sir. He has used the letterhead itself, sir, like that. So that means that to an extent it is one. But in that case, though he did everything, the finance company was put on inquiry. The reason, see, the clincher in that DVS case is, suppose DVS had got the money into the company's account, no problem. Doctrine of internal management will apply. Company is bound. Even though the other directors did not know about it. But in this case, it was deposited in the personal account. That is why exception to doctrine of internal. Where a company changes the name, it should paint or affix the old name with the new name with the former name. At least for 2 years. In the letterheads, formerly Dubacor Limited, NR and Company Limited, formerly Dubacor Limited. That's to go. So that everybody will know, oh, this is Dubacor Limited. Okay. Now they've changed the name. Okay. See, most of these rules are common sense. Once you understand the common sense, you will know. To a great extent, the erstwhile 1956 Act was highly driven by common sense. The 2014 Act also, 13 Act also, to an extent it copies the old law, it is common sense. In between, occasionally they will become slightly mad and do something God only knows why. Very rarely. By and large, The common sense is not affected, but grammar, I got it. I got. Because I'm a purist user of the English language, I feel very hurt when I see such bad and abusive usage of English. Sorry, I sound a lot like Sashi Tharoor and Lord Labakadas or Lord what is that? Macaulay. But what to do? See, English is a beautiful language. Should be spoken so beautifully. But what to do? Chalo. So if it is a OPC and all, these are nothing much. Yeah. Nothing much. Very important. Very, very important. When you want to change the registered office, change in registered office, there are 4 levels. 4 levels. All 4 levels I'm going to teach you now. Okay. Asan method. If you just look at this slide, remember it, yaad rakh dijiye, then absolutely no problem. Okay. First changing it. I'll give a simple example, you will understand better now. And it's all even a case study that I keep using in my final level, case study oriented questions also. See, there is one gentleman called Mr. Vikram Adekar, Vijay Adekar. Vijay Adekar is a technocrat. He qualified from the IIT and Mumbai, and then IIT Madras, and thereafter he went on to work in many companies, including Bajaj and other major automobile companies. Then he started his own business, Adekar Industries Limited. He started it because he is from Maharashtra. He started it in near Pune. Not exactly Pune, little outside Pune. Hey, it sounds little as if there's a real Adekar. No, there is no real Adekar. It's a fictitious name. But I have created such a family now. This Adekar has one wife, Vimala Adekar, was 2 sons, Vikram Adekar, Vijay Adekar, that entire parivar. Plus, I've created a company, a board of directors, public issue, entire thing. Fictionally, I've created a case study. So much so that I actually believe that there is a fellow somewhere called Vikram Adekar who's done what I'm telling. So this Vikram Adekar, he created this company, which was very successful. So the company was initially in Pune. So the registered office is in Pune. Let's say Pune. Right? Pune. Yeah. Now, so it is within the local limits of Pune. In Pune itself, earlier they were near Viman Nagar. Now they want to move to central location, which is better than where they were in the factory. They now want to move from Viman Nagar to central location. Beautiful. So they want to move within the local limits of the same city, town or village. No problem. Just simple board resolution, INC 22. Am I correct? Because there is time, 30 days you have to file. Within 30 days you have to file any change. That also INC 22 only. File form number INC 22. That's all. Your job over. You don't do it. Call a company. Hey, idhar aao. Aisa karo. Chal. Throw over. Now, he wants to move. What happened? He feels that registered office is in Pune, whereas everything happening in outside of Pune in a small village. I do any name some gaon you give ma. Okay, Shegaon. Shegaon is very far away from Pune. Okay, he is having a factory there. Okay, Shegaon is very, very far away. Okay, you name some name here, some gaon. Okay, in that gaon, this fellow is having a village. Ek gaon mein ek kisan rakhta tha, like that. He is in a gaon. Now, in that gaon, he wants to change his register office from Pune to that gaon, which is outside the local limits of Pune. But same ROC, na? Remember, Maharashtra has 2 ROCs, one in Mumbai, one in Pune. So it will still be under Pune ROC only, but outside the city, town or village of Pune, city of Pune. For that, what is the thing? You have to pass a special resolution. General meeting, special resolution. It means special majority, 3 times. Number of votes cast in favor shall be not less than 3 times the number of votes cast against, if any. There is a definition of a special resolution. So special resolution is written. Later on, when you come to management and administration, the faculty who is taking it will clearly explain to you what is special resolution. Abhi to Ordinary resolution means simple majority, means number of votes cast in favor is more than, jada hai, is more than the number of votes cast against, if any. Special resolution, number of votes cast in favor is not less than 3 times the number of votes cast against, if any. Okay, that is special. So special majority is required because it's a major decision now. All along you are in Pune, now you are moving to some gaon there. So there. No. So after passing the resolution, you have to give notice to ROC within 13 days. Again, INC 22. And remember, since you have passed special resolution, you will also have to file MGT 14. But to my knowledge, they do not ask you procedural questions. If they ask you something like this story, they want to move to place other than outside of the city to another place which is outside the jurisdiction, what is to be done? Advice. Then you simply have read, the company would be advised as follows. 1, a special resolution shall be passed for change of registered office from outside the local limits to the place outside the local limits. 2, the company shall file INC 22 within 30 days. If you write this, you will get full marks. If you write MGT 14 and all, they will fall at your feet. Suppose the number of marks is 3. They will, for writing this much, they'll give you 2.5. Suppose you write MGT 14, the examiner will fall sashtangam at your feet and give you 3 for 3. That's all. Okay. Now, now comes the point. Adhikar industry has become very big. It has gone for IPO. It has got so many shareholders across the country, and it is having, presence all over the world. Now they can't operate from a small gaon in Maharashtra. Where should they go? To the financial capital of our country, where all the major decisions are taken, where Mr. Ambani lives, where Mr. Amitabh Bachchan lives. Which is that? The city of Mumbai. So they want to move from Pune to Mumbai. Be careful. Maharashtra mein 2 hai. So they are moving from ROC Pune to ROC Mumbai. Am I correct? Therefore, procedure is slightly different. It is not enough if you pass special resolution. Baba, you have to pass a special resolution. You have to pass a special resolution. That is there. Because outside the local limits now. Got the point? It's a cumulative. Cumulative. Got it? You have to hold a board meeting, call a general meeting, pass a special resolution, file INC 22, and then you have to make an application to the regional director. In that application, you have to enclose the special resolution also. MGT 14, everything. Like I showed you now, for change of name application. Same way you have to do. And there is no form, just an application. And you go to the regional director, who will be sitting in Mumbai, Western region. Western region regional director will be sitting in Mumbai. So you file and you sob like that, you have to go to him and with your hands folded and you have to tell, they made an application. So please confirm it. Now the law says the confirmation should be given by the RD within 30 days. But of course, if there, suppose the company has not filed annual return, financial statement, has not complied with something, then he will say, boss, first you rectify that and come. So that may take some time. But if everything is pakka, within 30 days, you will get it. Thereafter, within 60 days, you file it with the registrar. 60 days of the date of confirmation, right? And then the ROC will register the same and certify the registration. That's it. The certificate referred to above will be conclusive evidence that all requirements. Friends, because of topic being like this, I am not giving a break. Kindly, if you want to take a break, see, I have got a tea here and I'm drinking it like that. Kindly relax yourself. Bear with me today alone. Normally, I'll give a break, not today. Okay, please bear with me. I know you're all highly intelligent people. You will not have a problem. Correct. Twitter users now formally Twitter because they don't want to do this. Okay. So thank you for your kind words, Mr. Kuldeep Nagar. Okay. So moving on. So this is a very simple. Basically, it's the regional director. And this will happen only for 2 states, not for any other state. Only for 2 states where there are 2 ROCs. Okay. That's why I gave the example of Pune to Bombay. Okay. So ROC to register the same and certify the registration within 30 days. Certificate shall be conclusive evidence that all requirements of this act have been complied with. Okay. and the change will take effect from the date of the certificate. Now, from one state to another state. Now, do you remember I gave an example of a company which was formed in Indore? 3 generations. The factory was started in Bavra by the patriarch. It was very successful. Then from Bavra district, they moved to Indore, capital city. And from Indore, they now they have become very big. So they have to move. They want to go to Mumbai. No, be careful. From the state of Maharashtra, Madhya Pradesh, they are going to Maharashtra. You got it? Now, here you have to be very careful because you are moving from one state to another state. It so happens, luckily, both are under the Western region. Otherwise, you have to apply to both the regional directors. For example, we had a client who moved from Kolkata to Chennai. So I had to do for Eastern region, and so the application made to Eastern region, copy to Southern region. Here, luckily, both are Western region, so Western region, Mumbai will do. So you have to make an application to the RD in form number INC 23. Also, remember, my dear friends, in addition to special resolution for change from one city, town, or village, in addition to, you have to also pass a special resolution for alteration of situation clause. Why? Because your situation clause would have said what? The registered office of the company is situated in the state of Madhya Pradesh. Now you have to change it to Maharashtra. So that resolution you have to pass. You have to alter the memorandum, everything, MGD 14, blah, blah, blah. Then the RD will go through it. It's got 60 days. And before giving approval, the regional director should ensure that there is no objection from creditors, debenture holders, including you have to get NOC from income tax, GST, everywhere you have to get NOC in Madhya Pradesh. The jurisdictional principal CIT, here CIT, who is handling your file, and the GST commissioner, they have to give a NOC that they have no objection to your going. If that is not given, then you give, they'll wait. Nobody should have, including in many big cases now, suppose the company is employing 2,000 people. The chief secretary of the state can also object. What can he say? He can't say you can't go. Really. After all, see, because Mamta ji was behaving like this, she refused to allow Tata. See, Ratan Tata wanted to build a nano factory in West Bengal. But see, the problem was he wanted ancillary industries to be situated very near. Only then he can manufacture 1 lakh. She refused to give that land. Therefore, Tata was not knowing what to do. Then, of course, our great Prime Minister, he made one single phone call. And he said, you are welcome to Gujarat. That's all. And then Chief Minister of Gujarat, our enlightened Prime Minister, he got that project to Gujarat. Okay. So like that, it is, what can you do? If the Chief Secretary of West Bengal objects, okay, you object. Because Chief Secretary of Gujarat will come and say, please allow him to come. Okay. So, company to file a certificate copy of the order of the RD approving the alteration with ROC of each state. So, both the ROCs. Okay. Within 30 days, you have to file. Both the ROCs. Both the ROCs will register, and the ROC of the destination state will issue fresh certificate of incorporation. The entire file will move. Actually, there is no file now. It is all online. So simply the control will change from this ROC to that ROC. Okay. That is all. The procedures are fairly simple. And I have summarized it in this manner, but don't write it in this format. Write it in line by line. But remembering easy. Right? Instead of reading content which is textual, I find that diagrammatic and columnar content is easy to remember. And flowchart is even easier. I use flowcharts, but not in this now, but some topics we'll use flowcharts and diagrams and all I use. Okay, arrow diagrams, relationship diagrams, all that I use for remembering and for teaching. So if you any other clause of the memorandum, Baba, name and registered office, special provisions are there. Any other class, object class, etc., capital class, just pass a special resolution and file MGT 40. That's all. Okay. Now, very, very important. Special provisions for companies which have raised money from public through prospectus. See, the company has raised money through prospectus. You remember what I told at the time? In the prospectus, that fellow told electronic vehicle, electrical vehicle. Based on that, people have given money. Now, after the public issue is over, share is listed, these fellows are telling, we don't want to do EV, we want to do software. Now, they want to amend the object class. So such companies shall not change their objects for which they raise the money through prospectus unless a special resolution through postal ballot is passed. So the idea of postal ballot is not only the shareholders who come to the meeting, even sitting at home, we can object. Even assuming many people have slept and some people have voted, the promoters have controlled it, they have passed the resolution. Got it? Even then, if any shareholder is dissenting, that is why details of the resolution should be published in newspaper, English and vernacular. And finally, the dissenting shareholder shall be given an opportunity. See, boss, meeting was held, postal ballot was taken, no meeting, postal ballot was taken, special resolution passed. Even then, I am a dissenting shareholder. That means what? I either did not vote or I voted against. Now, I have an opportunity to exit. That means what? I can say, I don't want to continue, give my money, in which case the company can purchase its own shares or any other promoter and shareholders will purchase the shares. So this provision really is great. This was not there in the 1956 law in this way. Okay, in this way it was not there. Now it is there. It's a really good provision. This provision protects the investors who have invested their money based on their original objects. Beautiful. In fact, this is nothing but doctrine of ultra vires in action. So in India, we have put the doctrine of ultra vires in the act itself. Statutorily, we have made it. So if you change the object, anyway, doctrine of ultra vires applies. But even if you want to change the object, they say a dissenting shareholder should be given his money. Not bad, no? It's a very good section, according to me. Though I'm highly critical of the 13 Act, and especially the grammar and language, some provisions are good. Somebody intelligent has thought and done it. Okay. So, of course, once you alter the memorandum, you will file special resolution, approval of central government, if any. Okay. And if it's case of name, etc., etc. Okay. And that change in the memorandum, once registered, once filed, should be registered, and the registration will be noted now. Unless that is registered in accordance with the provisions of this section, alteration will not take effect. So you have to, in other words, any change in the memorandum should become a public document. Should be. Only then doctrine of constructive notice can apply. So you can't quietly amend your memorandum and keep quiet. You have to file it to the registrar, and the registrar should register it. Once uploaded and registered, it becomes a public document. Okay. Got it? See, do you remember? No provision in the memorandum can ensure that in the case of a company limited by guarantee and not having share capital. Do you remember? In those cases, no person can have the right to participate in the divisible profits unless he is a member. Same provision here also. There, at the time of registering the memorandum, you cannot have a provision. Here, at the time of alteration, you cannot create any provision. That's all. What was said there, again, they are saying here, with respect to alteration of memorandum. Their original memorandum should not contain. Here, the alteration should not contain any provision. So, whatever explanation I gave there, if you did not understand, here also you will not understand. Sorry, I tried my best to help you understand there. Again, let us not waste our time explaining. You watch that video, same explanation only for this also. Company not having share capital, members will be entitled to dividend. Non-member will not be entitled to any share in the divisible profit. That's all. Nothing else. Alteration of articles normally requires special resolution. But when the alteration has the effect of conversion of private company to public or public to private, okay, having the effect of conversion of a public company into a private company, public to private, shall not be valid unless it is approved by an order of the central government. See, Private to public, no problem. Go, enjoy. I have no problem. But if a public company, you are now trying to come back to private status, trying to enjoy the privilege of private company, you have to go to the central government, apply, and get the. You got it? Private to public, no problem. Naked, what is our problem? Public to private, no. Okay. So you have to pass a special resolution for conversion. Then RD, you have to apply to the RD in E-form RD1 within 60 days. And documents, you have to give MOA, IOA, blah, blah, all that. Declaration from KMPs. See, once you convert from private to public, then you have to be very, very careful. Okay. In both cases, you have to file RD1. But conversion from, you have to get approval of the RD. Okay. Okay. Once the private company amends its articles to remove those 3 clauses I showed you now, automatically it will cease to be a private company. And all the provisions applicable to public company will apply to it. But if you want to convert from public to private, you have to get approval of the central government on an application made. Okay. So alteration of the articles, you have to file it within the 15 days. Okay, with the printed copy. Once it is registered, then alteration to be valid as if originally contained in MOA. Okay. So it becomes a public document, as simple as that. Any alteration in memorandum and articles, once registered, it in turn becomes a public document. Okay. Every member is entitled to a copy of the memorandum and articles. Also, every agreement referred to in all that MCT 14, or if any resolution is there or agreement, MCT 14, they are entitled to a copy. The company is bound to give. And copy should be given within 7 days of the request. Of course, you can ask them to pay a nominal fee. You did not give it free. A reprography charge, you can say per page 10 rupees, whatever he will pay. He pays it. But today, Baba, we don't need section 17 now. Any document which is filed with the registrar, I can download it. There itself, I can pay the payment and get it. But if you want to be on the safe side, you can send a letter to the company saying, we hear that you have sold the you have done something which requires special resolution. Kindly give the copy of the resolution. Because they might not have uploaded there, but still they have to give it to you. Okay. See, this provision will be very useful when there is a mismanagement of the company. Like in my example, DVS, or where there is an oppression. Not operation, oppression. Where one director or one member is not dealing fairly with the other members. Most of the time, majority is not dealing fairly with the minority. Though there are cases where minority can also lose. Okay. Commencement of business, we have already seen. Do you remember? After incorporation, within 30 days, you have to file registered office thing. Within 180 days, the paid up capital ka money hai na, that should be bought. 180 days. If it is done, they will issue commencement of business. Otherwise, if the registrar will believe that the company is not carrying on any business, it can initiate action for the removal of the name. See, this is without prejudice. Because in addition to, because there is another provision in final syllabus for defunct companies. So there again, if the certificate of commencement of business is not obtained, he can designate it as a defunct company. He may not strike off. Please note it. Once it becomes a defunct company, then striking off procedure is there. Separate procedure. But without prejudice, in addition to that procedure, and in addition to the penal provisions, they can also initiate action for removal of the name from the company, from the register. Okay. This is what happened in my case. That other Prometheus was already defunct. They were not functioning, but their name was not removed from the register. So we made an application for removal of from the register. Once the name was removed, it became available. We got it and we changed the name because they had some other name, Prometheus something. Prometheus, for those of you who don't know it, is a Greek titan. He's a Greek god, not a god. He's a man. He's a man. But Prometheus, actually, demigod, you can say. He was the son of a god. And so what he did was something really great. He stole light from the gods and brought it to the human beings. He was the man who brought light. He stole it from the gods, from Zeus, from the father of the gods, and he brought it to the men. And he taught the men how to use fire, how to use metal, how to forge metal. And so that way he is the first artisan, Prometheus. Okay. And so in a way, Prometheus, we say Tamasoma Jyotirgamaya. This was the man who brought light. So light is a symbol of knowledge. Tamasa is darkness. Jyotirgamaya is from darkness we go to light. So I believe that, constantly we should be moving from Tamasoma Jyotirgamaya. So that way Prometheus is the symbol of light, the man who brought light. So my consulting would bring light to to those, not simply earn money for me. The idea is to give solutions which are sensible and sustainable rather than make money and run away. So we already saw conversion of OPC to private, private to OPC. Whatever it is, you pass a special resolution, file the document and change. Obtain the approval and do it. Okay. Now, this is a very interesting section. I'm very surprised. Holding subsidiary, you're all extremely familiar. You are all authority. Point. Holding will hold shares in the subsidiary. But subsidiary cannot hold in the holding company. No company shall either by itself or through nominees hold any shares in its holding company. Meaning, clearly, subsidiary cannot hold shares in holding company. Similarly, no holding company shall allot or transfer shares to any of its subsidiaries. So, holding company ka share cannot be in the subsidiary. Exception, very, very important. In the examination, the main law, they will never ask you. Main law is very simple. Subsidiary cannot hold shares in the holding company. Okay. Exception. First, the subsidiary company is not holding in its own name. It is holding as legal representative of a deceased member of the holding company or trustee. See, this could happen in peculiar circumstances. I am unable to give any example. Just remember the provision. By some legal means, the subsidiary company has become the legal representative of a deceased member. Deceased means dead. Margaya. Deceased. See, deceased is different. Okay. That means that he is sick. See, English has same pronouncing words, same sounding words. Deceased, sick, deceased, dead. So I would say a person will become deceased once he becomes deceased. Okay. So the point is dead member ka legal. How it became and all, I'm unable to think. If any of you is putting a query, so I'll give you example, I cannot give. But if at all they become legal representative, simple logic, he is not holding that share qua subsidiary, as a subsidiary. The subsidiary is holding it as a legal representative of a deceased member or as a trustee. You got it? Or as a trustee, not as a. Okay. Next is very, very important. The next exception is very, very important. Where the subsidiary company is a shareholder, note it, your honors, even before it became a subsidiary. See, think about it. DEF Private Limited is holding shares in ABC Private Limited. Already, it purchased the shares in 2024 January. In January 25, DEF Private Limited became a subsidiary of ABC Private Limited. It continues to hold the shares. Is it correct? Yes, because this comes under the exception to section 19. Okay. So we have almost completed the topic. In fact, I'm very happy. I thought with all my blah, blah, giving stories, bories and all, whether I'll be able to complete the topic. I have. But what I will do now, there are two assignments. Let me complete and then let me become proud of what I'm doing. So these are all definitions, I don't want to read it. I'm just giving it appropriate place. See, in the institute material, everything is come in one place. You may have to go there every time. This is about service of documents. Documents define ho gaya. It is defined. So therefore, it is anything, summons, notice, requisition, order, declaration, form, register, document. Okay. Whether issued, sent, or kept in pursuance of this act, under any other law for the time being in force, or otherwise. See, this otherwise is also there. Any document. Okay. Now, so here now we are going to see service of documents. Meaning what? Service means delivering. Service. How to serve? See, in the hotel you go, the server comes and serve. What he does? He keeps it on the table now. He gives it to you. So service means giving the document to the company. How to give? Obviously, company cannot take it. So some representative only will take it. How? First step, you already saw that. A document may be served on a company or an officer thereof by sending it to the company or the officer at the registered office. No other place. Only registered office. You can send it post, speed post, registered post, courier. You can send it by registered post, speed post, courier service, or leaving it at its registered office. That is, you can go personally to the registered office, give it, but be on the safe side. Whenever you deliver a document to any place, do not come out of that place without obtaining an acknowledgement. Friends, if you're going to the income tax department, sometimes the bureaucrat will arrogantly say, I won't give. You say, I won't give you the paper. I am entitled to the acknowledgement. In fact, once in the income tax department, one clerk told me that I won't give. I said, who are you to say I won't give? Even if I file some stupid document, boss, you have to accept it. Then your boss let him deny it, he let him do whatever he wants. Then I went to the additional commissioner and I asked him, sir, please let me understand the law in this democratic country. As a citizen, am I entitled to enter this office and file a document? Yes, you can. Can I do it in the appropriate tapal? Yes. What happens if the tapal clerk refuses? I call him and fire him. He called him and said, whatever document he's giving you, take it and accept it. Okay. So that way the additional commissioner had awareness. Because for all, there are IAS officers, yeah. They're not ordinary people. Like, seriously. I have the highest regard for the executive mechanism in this country, the administrative services. They're highly intelligent people. Okay. Yeah, see, because of the British heritage, sometimes they think they are themselves Lord Curzon and Lord Macaulay. But if you go through that arrogance, they're all highly knowledgeable people. And they know what they're doing. It's unfortunately, on the one hand, they are unable to do anything because thanks to the great representatives we elect and send to the parliament. Okay. However, where securities are held with a depository, the records of the beneficial ownership may be served by such depository on the company by electronic notes. Simple was, later on when you come to share capital and debenture, you will learn dematerialization. This is too early to teach you. If the shares are dematerialized, then all communication will be served by the depository on the company through electronic mode only. Similarly, serving of documents to registrar or member. Please note, to member. See, to the member also you can serve it at the address given by him in the application and nowhere else. You keep on changing your address, that is not my problem. You are given one address now in my record. To that address only I will send. And if it's a dematerialized share, where it is not in physical form, then I will only deliver it to the email address given by you and registered with the depository participant or to the depository. And my job is over once I send it by email. Dematerialized shares, no posting. Check out if your father or uncle or you are having a share. If it's a listed company, 100% dematerialized. That means AGM notice will come by email. Any notice will come only by email. They need not send by post. Okay. But other than dematerialization, post, registered post, speed post, courier, a person or agency which delivers the documents and provides proof of its delivery. Definition. Courier is defined. By delivering at his office or address by such electronic or other modes. So later on, when you come to dematerialization, remember, if the shares are dematerialized, they are not held in physical form, then only by electronic means. But that's very easy. I'm getting so many mails. I'm so happy. Which is important, I will save. Which is not important, I will delete. Okay. So in case a member requests delivery of documents through a particular mode for which he wants some special type of delivery, then he has to pay for it. Okay. In the case of a Nidhi company, okay, see, Nidhi companies are, I've already explained it, I think, they are finance companies where they accept deposits from members only and they will lend to members only. So it's a very closed group, Nidhi. So in those cases, everybody almost knows each other. So they are saying service can be on members who hold shares of more than ₹1,000 in face value or more than 1%. Other than those members, it is enough for other shares. So if you're holding shares more than 1,000 in face value or 1% of the total paid up share capital, whichever is less, then I have to serve physical notice on you. Otherwise, I will simply circulate it in the newspaper and also put it up in the notice board of the Nidhi. See, usually when you go to deposit money in a Nidhi company, they will make you a member. How? By giving you 10 shares. 1 share, 1 rupee, or 10 rupees per share, 10 into 10, 100 rupees. Those 100 rupee, 10 rupee shareholders and all, I need not give notice by post. It is enough if I give an advertisement in the newspaper and put it up in the notice board of the Nidhi. Okay. See, these are all I'm explaining because this is a long form class. Otherwise, not important from exam point of view. Okay. Since it's the full class, I'm covering everything. Okay. Document of or proceeding requiring authentication by a company, it is enough if it is signed by a KMP. Okay. Bill of exchange, hundi, everything should be signed by an authorized key managerial personnel. Now, in the case of bill of exchange, if the company has a common seal, then it should authorize any person under its common seal and that person will sign. If it does not have a common seal, then at a board meeting, you can authorize that one director. Or where the company has a company secretary, it can be authorized by director plus one company secretary. Okay. So this is execution of bills of exchange and all that. So I'm very happy that we could complete this topic well within the time allotted. And we can also, I don't know whether I spoke good Hindi at all. My Hindi is very bad. Sometimes, see, I also know that many people attending are all not natural English speakers. They are basically Hindi speakers. So I try to use Hindi, but my Hindi is bahut ganda hai. Please don't even expect me to speak good Hindi. Because, okay, but thank you, Mr. Mustafa. You may not have to read the material. My suggestion, you keep the material with you. See one more revision you do with the slides. These slides, inshallah, will be uploaded tomorrow along with 2 assignments. So what you should do is, you should attempt those assignments. And I will also put up the solutions. You can refer to the solutions also. Okay. So that is the idea. Thank you very much for a wonderful and great session. Look forward to, inshallah, meeting you again in the course of this session sometime, maybe in the future. Wishing you all the best in the meantime. Thank you. Bye.
Good evening, students.
Yeah, madam, I'll just stop sharing.
So good evening, students, and good evening, sir. Sir, you actually teach very well and you apprise the students with not only what is written in the law, but also with you give them practical insights with the kind of experience that you have. So that's an added advantage. And as far as Hindi is concerned, we are catering to students all over India. So most of the faculties, we try that they should speak more in English, only from the point of view of that we cannot cater to a particular region as of now. In times to come, with the help of AI or something else, we may start catering to such things also. But as of now, we cannot cater to a particular region. So, sir, don't feel anything about that.
I'm not feeling. No, I feel bad that I'm unable to reach the student. My only regret, I didn't learn Hindi, which is such a good language. I didn't learn it. That is my
Perfectly
regret.
fine. Thank you, sir.
But I'm sure in future AI will improve that they can wear an earphone and any language which is spoken, they will get the message in their language.
Yes, yes,
It will happen.
that is there. That is there. That's why I said that with the help of AI, things may
Yes.
soon be like not only pan India, but pan India in their regional language. So, students, we were doing this chapter 2, incorporation of companies. Okay. And I think sir has completed the chapter beautifully with you guys. And a very good evening, my students.
Can I leave now?
So,
With your permission? Can I
sorry,
leave?
sir?
Can
Yes,
I
sir.
leave now?
I wish you may, sir.
Thank you.
So,
ma'am.
students, I have a small recap kind of a thing for you guys. And in this, I will take like 5 to 7 minutes of yours. We have worked on this model before also, where we will be doing the whole of the chapter in the sense of, what should I say, riddles. Now, the point is, all of you need to respond to me on the chat box. And apart from that, I have one more request to all of you. You have been telling me, I have been receiving a lot of mails with respect to, okay, ma'am, we don't know how to remember the section numbers. Though it is not mandatory at this level to remember the section numbers, but as I told you in the first class itself, that as a good practice, you should try to remember. So today you may be knowing the answers. I am confident about that. The point is that you have to give me the section numbers. Like section 1, not section 1, since this chapter started from section 3. So you have to give me the section numbers also. Although there is an answer to it also, so you may write that also. And in this, if it's a memorandum, so write MOA, and articles, write in short forms. So let's start without wasting much time. I hope all of you are ready. Can you see my slide? Quickly, somebody answer. Okay. So the first is, I come alive when 3 or more unite, or just 2, and the goal is right. With lawful aims and ROC's grace, what section gives me my birthplace? So you must be knowing the number and need to know what they are talking about and what is the relevant section number. Fast. The answer is almost correct. I need to know the section number. Krishna. I alive. What comes alive when there are 2 people? 2, minimum 3 or minimum 2. What comes alive? Not getting the correct answer. Okay, so let me give you like this question. Okay, someone has written registered office, but right now the point is, just try to understand what the question is asking. Registration, private company. Okay. The point is, if you see, they are saying what comes alive. It's not the company comes alive. Okay. When there are 2 people or minimum 3 people. Okay. So, and it should have a lawful aim. What should have a lawful aim? Registered office need not have a, we don't say about registered office that it need to have a lawful aim. We say it about the company. Okay, can you have a company for illegal purposes? No. So it's talking about the company. It's talking about the formation of a company. So this is your formation of company, and the correct section is section 3 talks about when you are saying that minimum 3 people or minimum 2 people are in. I hope that's clear. You can't say just a private company because we are also talking about how many people. Great. So it's clear. Section 2 clause 20 और section 3 क्या बोलते हैं? Number of people तो बेटा वहां से define हो रहे हैं. So next करते हैं. तभी we have drafted these riddles. Okay, so the next is I am the charter. The company's frame, broad framework within it works, object, name, and where I claim. Without me, there is no foundation true. What section lays out what I do? Section 4, correct. And also write that MOA, very nice. So, okay, very good, Gayatri, because she has written both the things. Okay, so that's why I told, yeah, MOA, and it's section 4. So next. I am the rule book, flexible yet tight. Now, in the earlier riddle, we talked about the external, like the broad framework. Internal governance is my right. For procedures and power, I set the way for what? Procedures and powers. In which section do I stay? Mustafa, correct. And you try to, yes, Krishna, correct. Very good. Adil has given me both the things. Anubhav has given me both the things. Correct. So my students remember the section July. Okay, so everyone has given me the correct answer. Next. MOA में try sway मतलब अपने path से इधर उधर थोड़ा सा होना. But I ensure, now this is specifically with respect to the section, but I ensure the act, which act? The company's act holds the way. If conflict knocks on company's door, which section rules forevermore? Correct. Correct. So it is section 6. And which is section 6? It says act to override memorandum of association and articles of association. Very good. Very good. So if you see, आप लोग section numbers लिख पा रहे हो. अगर आप यहाँ पे जवाब दे पा रहे हो तो डेफिनेटली आपको थोड़े थोड़े सेक्शन नंबर्स याद होने शुरू हो चुके. I serve no profit, yet aim so high, with social purpose as I fly. License I need to act in it. Which section sees this company made? And in this case, many a time you will be referring the company with the name of the section of. Everyone is giving me the right answer. So it's section 8. Correct. Everyone is giving the right answer. Section 8 companies, the non-profit organizations. Very good. So everyone has given the right answer. The next is between company and member I bind. A contract written you will find. Rules and rights that just won't bend. Which section make these documents friends? A bit tricky because you know about memorandum, you know about articles, but what is that section that tells about the dash nature of memorandum and articles? Correct. Anubhav, that is correct. Okay, Deepika, that is okay. Deepika, you need to wait for this answer. Any other student? Given Gayatri, I wait. So any others? Okay, so who else has given me the answer? Okay, section 8, everyone, Rupesh, July, everyone has given me the correct answer, but this section is the section 10. So which talks about the binding nature of memorandum of association and the articles. Today, when you are revising, do revise this section specifically. As in terms of that, just like how these sections are having an effect, binding effect on the company. Okay, so let's just pick up the speed. 2 to 3 more are there. I mark the place where letters come within 30 days. Declare your home. Paint my name and number 2, which section tells what you do. Okay, I'm just giving you technical team, can you give them an unmute option to all of them? Technical team, give them an unmute option to all of them for like last 2 to 3 minutes. Okay, students, just speak up the answers. Speak up the section.
Section 13.
Okay.
Ma'am.
Any more students? And tell me, if you are saying section 13, then tell me the name of the section also. Quick, quick, quick. That's why I've given you an unmute option now. All of you, you can simultaneously.
Registered office,
Section
but I don't know the
13,
section.
Registered office, and the correct section is section 12. Let's move to the next. You wish to change your aim. Aim matlab hamara object. Or move your state or change your name. Special resolution is your guide. Which section lets the memorandum of association slide to sway from what they were wanting to do, already decided to do? Quick, quick, quick. No answers? No, I want the answers, not so I will not be checking the chats. So answer me, quick.
It is about alteration of object clause, though I don't know the sections.
Okay, alteration of memorandum.
Section 13.
Correct. The correct section, both of you are correct. The correct section is 13. And what? So next. Okay, I have like missed it. Okay, once you change your memorandum or articles rule, you must tell ROC as a golden rule. If you forget, you might get fined. Which section keeps this in mind? कौन सा सेक्शन है कि जब आप ऑल्टरेशन करते हैं उसके इफेक्ट्स एंड फाइलिंग से रिलेटेड है?
16.
Section 15. 16 is with respect to rectification of name. I don't have
Names.
a slide. Okay, this is section 15. I'm not saying that you have to remember all these sections. It's just that I wanted to tell you that it's easy to remember the sections. You all, whosoever has now given me the answer, see, you were remembering at least few of the sections. Just think about it, that if you would have read those sections 5 or 6 times or 7 or 8 times, then at that time, I'm sorry. So at that time, you would be in a better position to write the section numbers even in examination. It's not such a difficult. Okay? So any questions? Or we can close down today's session. Okay, technical team, I'm not getting answer. Oh, thank you, Kuldeep. So that's all from my side, and see you in next class. Till then, take care, have fun, and revise. See you on next Monday. Yeah. Yes, done. Thank you, technical team.